Good morning, good morning, good morning. It's Tuesday, it's February 18th. We are back in court in Massachusetts. Why? Well, Karen Reed is back in court today. Last week, we read through the motions that were filed. This week, we are hearing the attorneys argue in court regarding those motions. So the attorneys are going to be talking about the metadata, I am sure. We are going to hear some of the initial motions, but what they are not going to address today is what many of you are waiting for, and that is the motion to dismiss. That's not being argued today. It hasn't been turned in yet. The defense has a few more days. That is due February 21st, and that's not going to be argued until the beginning of March. So for everyone that's going to ask, why hasn't this just been dismissed yet? I understand. That is not the question before the court today. The court today is hearing the motions regarding discovery, the motion from the defense to reconsider what they have to turn over to the prosecution and when. We'll see if the court just rules outright or has a hearing for the defense motion to exclude one of the prosecution's witnesses. Those are the things we're going to hear argument on today. I don't think we will be in court for an entire day, but fingers crossed, because we never know. We never know. Court started a bit late today, which gave me a little Zoom room, which is helpful because one of my kids was sick last week. The other one is sick this week. So it has just given me a little bit of time this morning to take care of all of the things going on at my house. I am still a bit under the weather. You'll hear it today. Better than I was, but not good yet. So for all of you who are ready to go to court, thank you. For those of you who might be ahead in the hearing elsewhere, thank you for no spoilers. I'm sure the lawyers are going to get a little sassy today. And yes, I've got one of my new spicy Larnard hoodies on. We're in a hat today. Why? Because the hair was not hairing. The hair was just like, girl, what we're not doing today. And I was like, fine, we need to stream. We're not going to sit here and fight with our hair. We have other things to do this morning. And I have a cold brew this morning because Dr. B brought home a treat, which is great because breakfast is sitting here on a tray. So for those of you that are going to eat while we're in court, me too. Me too. We're going to do all the things. I can't wait to see what happens in court today, because I'm actually really interested in the more information we might glean, because I felt all kinds of ways about these motions last week. So I'm ready. I'm ready. Are you ready to go to court? I feel like we need to go to Massachusetts and we need to roll the intro. So we're going to do both. So let's roll the intro, then let's go to Boston, and then we're going to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, let's go to court. I felt like we needed to do both. And I know you missed it. I know you missed it. And so because court started with the OnlyFan, I know you missed it. I know you missed it. I know you missed it. So let's do that. Let's do that. Is there sound yet? No, there's not. Will we make sure sound is good? Yes, we will. Yes, we will make sure sound is good. All right, let me make sure. Sound is good. We're going to zoom. I knew you missed the fan. Are we going to zoom? Yes. Yes, we are going to zoom. But we missed the OnlyFans, so we had to say hi to our friendly fan in Massachusetts. Let's not creep on what Karen Reed's typing on her computer in court camera. Let's just, yes, she's the defendant in a high-profile case, but also, let her be. Let her be. I want to hear the hear yees. If we miss the hear yees, I'm going to be sad. I just want to hear the hear yees. I'm ready.
So
we missed the hear yees. Okay, the hear yees might have happened before they went on the record and before the camera started, because it seemed like they were at sidebar. So I will do my best. Hear ye. The Honorable Beverly Cannoni in session, sitting in Norfolk, and on the internet. What else? Draw near and pay attention, and ye shall be heard. Something like that. Court is now in session. We did our best. We did our best. All right. Those are our best hear ye's. Those are fake hear ye's, but those are the best we can do. So the attorneys are all up at sidebar. If we can sidebar. So that's where we're at. Oh my gosh, Charlotte, I love that.
Is start with,
they're so
now,
good.
I don't know if you all have the paper numbers on these. You probably do if you've been looking at mass courts. So
I do.
Commonwealth's motion for records.
It's a lot of motions.
WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
So that's where we're starting. Let's back up real quick. Emily, what motion did they say we're starting with? I don't even have my notes out yet. We're starting with the Commonwealth's motion for record. Hold on. I need a document. Oh, I need a document. But we're starting with the Commonwealth's record for motions. This audio is coming into my ears mono. So if you hear it only out of one earbud, this I thought was stereo, but this one's coming into me mono, but it is the loudest one we have. So let's back this up. I want to hear exactly what hearing. I appreciated it when the court read out everything we were doing in a day. That's not happening at the moment.
We'll have the paper numbers on these. You probably do if you've been.
Hold on, let me back up. There we go.
What I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at mass courts. So Commonwealth's motion for records.
Commonwealth record for motions.
WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
So the Commonwealth records for motion for records is up first. I said that backwards.
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
So Karen Reed has recently done an interview. I'm not surprised that they are asking for all of the uncut from Boston 25. So that doesn't surprise me at all. So we are, I think, going to hear, well, it sounds like Boston 25 is like, yes, if it didn't make it in, you can still have the uncut interview. So I'm not surprised by that, but they said March 1st. So, okay. I haven't watched
so with
it yet.
the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you said?
They'll have it on
All right,
before
great.
March 1st.
Okay.
Perfect. March 1st. Yay. Next
All right, so
motion.
that motion is allowed by agreement, and
I love it when we can move on quickly.
the order is right here, Mr. Clerk.
So the court, because it's agreed, the court just signed it and handed it over. She's done
All
a lot
right.
of memo orders.
Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's
I'm sure it
opposition
was.
in response. Do you have a paper number? Okay.
We haven't seen the opposition yet. It looks like it was just filed today. That's what the court is saying. This is the one we went over earlier last week, the forensically sound footage.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument.
That's not
you
us.
Can give me that?
That's not you. That's the
Great.
court.
Thank you.
Sorry, that garbled on my end a little.
Right. Okay. Who's arguing this motion for the defendant?
Mr. Jackson. We're not surprised it's Mr. Jackson, but this is going in more of a date order. So we're getting into the motions that came in first, and now we are getting beyond, then we'll get into the ones that came in late last week. So the forensically sound copy is very much something that we are looking for. I'm curious.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we
Really?
had no choice.
I told you all this was kind of a placeholder. This is we are demanding it. I don't think you can give it to us, but we are demanding it.
Following the court's instructions, meeting with Mr. Brennan after
And yes,
the last hearing,
Jackson
which was
just
the
talks
6th,
that fast.
about the download of the video footage that apparently has been stored,
get
or
my
at least we
notes up.
believed at the time last week,
Emily, get
had
it
been
together.
stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He
I don't
claims that it
know
was
why
news to
they
him.
couldn't have all done that
putting
when the
aside
expert was
how
there.
Odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th.
And now we're here.
So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan, and it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time.
Also, an iCloud makes literally no sense. An iCloud makes literally no sense at all. Like, most work computers in a police department wouldn't even have an iCloud. So the iCloud situation makes no sense. I have so many questions. It makes more sense that it's on a video drive, but it's so confusing. And Kate Manning in the chat said it's what he said in court. In court, he said some kind of cloud. And the department video storage might have a cloud backup, but iCloud makes no sense. So I'm very curious to hear more about this from both sides. It makes none of the sense at all. And none.
So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload,
it should,
for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance.
I love Jackson's face. Did you see him pull the curse words back into his whole face? He pulled all of the curse words back in. He just went, pulling them back in, because the key here is, seriously, Your Honor, WTF is happening? Why is this still going on?
To be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download
Brennan,
of the videos.
what?
You don't get anything else. If you want anything else, go to court and file a motion.
Okay.
Which is why
we're here.
We had to file this motion. We don't think
Brennan,
that it was necessary.
really?
This is metadata that is literally in the Commonwealth's possession as we speak.
We hope.
They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day.
It shouldn't be hard.
And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to.
Well, it depends how broad your request was.
They know that they've got it, or they've got access to it. Why wouldn't we?
I don't know that they know they got it.
These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of the Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford.
Yeah, we've heard
called
this.
Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there.
Right.
And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory.
Right. What happened? Who touched it?
Because the audit trail will tell us information that we won't otherwise have from the raw video.
That makes sense.
How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed?
Who took it off?
Has it been accessed
Who touched
at all?
it?
Has it been altered? Has it been manipulated? Has anything been deleted?
No touching.
Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr.
That's fair.
Mr. Brennan. We are surprised that he would object to that, because we would think that in point of fact, he would want those same data as well.
My only note on this, it depends on how it was asked, because we've seen Jackson ask for the entire work computer, which is objectionable. So I think there's a balance here. But it really just depends. If they're just narrowing it down to that video, then yes. And yes, you guys, I do see Alessi's remarkable, because all of us are obsessed with them. If I had this when I was in court, I can't even tell you how excited I would have been. I get it. I get it.
Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Okay. That was pretty clear. I'm very interested to hear the response to this.
It seems like another effort to portray some type of injustice brought upon the defense, that half the facts are left.
Oh, that's the way we're... Okay. Well, I guess that's the direction we're going, aren't we? Another effort by the defense to portray an injustice where only half the facts. Okay, then tell us the facts. I want to hear. I'm curious. Yes, I backed up because I was talking. He's just coming
Seems
in
like
hot.
another effort to portray some type of injustice wrought upon the defense that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would it be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence to have off-the-record agreements with the defense.
Ooh.
There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence,
Oh, the judge isn't going to like that.
the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the
he is
defense to an entitlement
pissed.
that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When
I'm going to need that
would
name.
ask,
Hold on. Pietro, I think he said. I'm backing it up because I wanted to hear the name.
Retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say,
So an
you're
external
already
hard
involved
drive.
in the process with the NVR, DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I
They
don't want any video
said-
being overwritten or destroyed.
They said, we want a forensic copy.
It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously
That's
hidden about
strong.
this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also
I think it's better
it
to
seems if it's on videotape,
tape it.
it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to
Well, they want the metadata.
meet our responsibility,
That's not
download the
wild.
videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the
Becomes
defense, and then they
complicated.
can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today is, it'll be done by the end of the week.
You want to maybe, I'd be heard briefly,
Yes.
very, very briefly.
Take your
Oh,
time.
boy.
Thank you.
The court's like, take your
Brennan's
time.
Confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth.
Right.
And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation.
He didn't mention it at all.
Because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on. This is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them. And he
Probably,
should want to
maybe.
give those over to us. He just indicated that this detective file, whatever it is,
Should
is
be,
a
but
hard
probably
drive.
aren't.
Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the
Wow.
data that is behind the videos as well.
Seems to be
and
quite
I wouldn't
difficult.
be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word.
He did
Nobody's
say
talking
that.
about oppression. We're talking about fairness. We have been told from day one, before the first trial ever
Brennan
started,
used all of the words.
This court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more
That little bit of echo is coming out of court. It should resolve, but just so you know, it's coming out of court. It's not you.
video. Happens to be an inverted video. Where
It's
did that come
inverted.
from? Then on October
Yeah, where did it
24th,
come from?
We get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the
October 24th,
Fourth.
did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're
There's
asking.
handbrake on it, I'm
There's
sure.
metadata associated with all those things. It's not a hard ask. It's not a heavy lift. There's no reason to justify, well, you know,
It's
what,
a
I'm
heavy
just gonna
lift if
drag
it's
and
not
drop
there.
this and you get the video and nothing associated with the video. That's all.
That's
we're
the
asking.
problem.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate.
That's
If
the
they want
point.
to come, they're invited. court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take
I don't know
a
what
look
that
at the
background noise
system.
is.
So if there's something they want, then we'll copy it for them.
He says it's beyond our duty.
Thank you very much.
It's beyond our duty, he says.
All right, Ms. Gianetti, the next one should be fairly quick and simple.
All right, that's the end of
motion
that.
for Pro Hoc Vici.
So we've got a new motion, Pro Hoc. Let us zoom to that. But again, the fact that there is consistent new information, or it seems like there is consistent new information about how these videos are stored, has got to be tremendously frustrating for the defense. And the Commonwealth has said, well, it's here. No, it's there. No, we don't know where it is. No, we don't know this. No, I don't know about that. The defense cited case law that seems to indicate that digital evidence, they are also entitled to the metadata. The Commonwealth says it is our practice to take the video and turn over the video. The defense is asking for a forensically sound copy. There should be a turnover with whatever data there is. However, the data the defense wants and the data they're going to get, if they get metadata, are not the same. Because any metadata they're going to get is the metadata from where it is currently stored, not the original metadata, which is probably gone. But the Commonwealth said, finally, we don't think we can accommodate that full request. We think we are turning over what we are required to turn over. So let's get to their motion for Pro Hoc for defense.
I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And
So
would the
she wants an
court require
affidavit.
further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
So wants an
May I have just a
affidavit.
moment with counsel?
Which is what she asked for with Alessi as well.
Thank you, Your Honor.
Okay.
The next one.
Next motion.
Yes.
Oh,
Yes. Yes.
you want to be heard on the Pro Hoc? Oh boy. Okay. Well, the Commonwealth would like to be heard on the Pro Hoc Vice, so we're gonna see what's happening here.
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I
Can we go back to the person speaking?
want to share with the court.
Okay.
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing.
Yes.
I think it's a very fundamental right. And I don't think
Yes.
the Commonwealth should dabble in taking a position trying to prevent
Yes.
an accused from having counsel of their choice.
So what are you doing? So what are you doing? What are you doing? Why are you standing here? Your Honor, let me tell you all the reasons I shouldn't be speaking. But let me continue.
That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney.
Well, that's the
And
issue.
that is something that I think the court should consider and be thoughtful about.
Put it in your
For
opposition.
a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney.
We're not going to get into this too much because I have tried really hard with this case to not get into all of the side litigation that is going on in this case and just focus on this trial. However, I will point us back to what we saw in the Rust case, where you can have mutual defense agreements where the attorneys can save information or share information. You don't have to have an attorney on your team to still share information. And if both clients agree, there is nothing wrong with that. So just so we are clear, even if the Commonwealth is like, well, this attorney represents this other individual and this other individual is not related, but there's related litigation going on, the attorneys can still sign a mutual defense agreement and still share information. So it's not necessarily an issue. So also, for those of you asking if it's a conflict, look, there are some conflicts that are waivable. And this might be a circumstance, without me knowing more, that the conflict is waivable. So I have not covered all the side litigation, so I cannot tell you that. But the Commonwealth has some thoughts, and the defense and that attorney's current clients really get to make those questions.
There is a history of documented evidence showing the sharing of discovery between the parties.
They're allowed
And
to.
inevitably,
I'm going to back up and I'm going to stop talking. They're allowed to share discovery if there's an agreement with the clients. Unless there's a side note, unless there is some kind of impoundment order or protective order where they can't. They're allowed to do that.
a symbiotic relationship.
Let me back this up and then I'm going to stop talking. Who is the other client? For you guys asking who the other client is, some of you have ridden with me and not following all the side litigation, but Kearney, I'm going to get it wrong, who is known around the interwebs as Turtle Boy, who has been involved with this case since the beginning of this case gaining popularity and was covering it long before I think almost anybody else was. But there is a bunch of side litigation going on around all of that. Do I have the information to give you the full background on that? No. Can I tell you there is side litigation going on that? Yes, that. There is side litigation going on, and he is somebody who covers this case, who is involved in this case, who has litigation going on surrounding this case, who is in court in this case, and his attorney wants to come in or the defendant wants his attorney to come in as part of the defense team here.
Also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney.
And that's not wrong.
There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case.
And
Not
if that's true,
unmindful that
that's
there's
not
over
okay.
a dozen indictments against Mr. Kearney, which Mr. Bedrow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Bedrow, Mr. Bradle, who's Mr. Kearney's other attorney, and the defense attorneys in this case.
That's okay.
There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Bedrow, Mr. Bradle, have an understanding with the defense attorneys in this case.
That's
That there's
also
an
okay.
ongoing, long-term, implicit mutual assistance and mutual defense.
I understand that Brennan wants you to think there's something wrong with this by the tonality of his voice, but there's nothing wrong with this. And for those of you asking, is that Runkle on the laptop? That is Aiden Kearney, who they are talking about in court with, yes, Runkle on his laptop. That's yes. This case, the outside comes to the inside in this case quite a lot. But there's nothing wrong with what he's talking about if the clients agree. The clients are allowed to agree to share information. If information is impounded, there are some limitations, but that doesn't seem to be the case here. And yes, it does seem that Turtle Boy has brought his emotional support Canadian to court today. Why? I don't know. But yes, emotional support Canadian. I doubt he's watching in court. It just seems like a freeze frame.
That they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney.
Exactly. Mutual defense is allowed.
That the attorneys in Mr. Kearney's case, Mr. Bedrow, Mr. Bradle, have an understanding with the defense attorneys in this case. That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time.
They're allowed to do that.
Now, the Commonwealth is not entitled to any product of a mutual defense, but
Correct.
it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte.
You're not entitled. Your Honor, it's not something I'm entitled to, but maybe you should delve into it, sir. I said it in other cases. When you play your hand that you really don't want an attorney to participate in something, it's probably going to backfire.
It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation.
There's a sanctions
of
motion?
Protective orders in this case.
That's a problem.
In the discovery in this case,
I'm going to make an asterisk and a note here. If I say that's a problem, please add in the note, if proven / if true. Because there's a lot of stuff that's been said in this court that we have not seen bear out. So do not please take it as me saying that that's true. If it's proven and if it's true, then it's a problem. I am not saying that it is proven and or true. But if there is a sanctions motion, I want to see it too. But again, a lot of stuff has been said in court that has not borne out.
a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to Special Attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants,
So this is your objection
that
then?
position is going to be a difficult task to manage, and I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it,
If protective orders
then
are
nothing
violated,
will.
that is a reason to keep
Then
someone
nothing
from
will.
ProHawk. If
and so
that has
we know
happened.
this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each.
Oh, because phone
And
records.
so, not to speculate, but
Attorneys are also allowed to talk to people. Violations of protective order is the only thing that's really substantive here. And if that is proven, then it can be a problem for somebody to come in pro hoc vice on this case. I am not saying that is proven. I am not saying that's not proven, but it's something that the court can consider. But Brennan needs to then make a formal opposition. Then make the opposition. Make the opposition and prove to the court that protective orders were violated by that attorney. And if that's true, if that's proven, then it's a problem. But that's different than a mutual defense agreement where they share information that is not under protective order.
But having
It's
a
not the same.
mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case.
This is going to get interesting, isn't it?
And that concerns the government.
Yeah, it seems to.
And so while I do not object to Attorney Betterow, they should have as many lawyers as they want.
Your Honor, I'm not objecting. I just have concerns.
I think the court should have some caution and some concern.
I'm just
and should
objecting.
consider
I mean,
some
I'm not
type of
objecting. But
inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the
He's a
court to
non-party.
consider assuring itself
non-party.
of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay.
Okay. That's going to be interesting.
Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay.
And I think that they'll be able to address those issues in the
All
affidavit.
right, the next one, I believe, is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss.
That's
and
just going to be
Angela
signed.
Relatively
Do
straightforward.
we
but I'll
need to
create
hear anything from you, Brennan? Brennan, pipe down.
Your Honor, you provided us the full
No, it just, A, that's a very old picture. And B, I don't know why we're all in court today,
audio.
but I don't understand what's going on the laptop inception, but sure. I'm definitely not anybody. Well, maybe I am. Chad, am I the emotional support streamer where we're all just yelling the same thing at the same time? Look, here's the thing with the motion for pro hoc vice. The court does not want to invite further fuckery into a case. The defendant has the right to counsel of her choice. If there are concerns that protective orders had been violated, then the court can evaluate that in camera and ask Yannetti about it and ask Betterow about it if appropriate and go forward in that way. They can handle it in chambers with the defense attorneys without the Commonwealth. If the Commonwealth is concerned that protective orders had been violated, it is an appropriate thing to bring up before the court. I can tell you how feisty I got when protective orders were violated in my cases, because it puts people at risk. And if that is what happened, then it is a problem and it will be a problem for the court. If that's not what happened, then it should be pretty easy to sort out. So let us continue on with this. And for those of you that said lawyer, had Betterow on his podcast, that might be something that the court will also look at if somebody's given a lot of comment on this case, that can change things. There are a lot of protective orders in this case, Dana. There's a lot of protective orders in this case over different material. They call them impoundment orders in Massachusetts, but there are quite a lot of them here. So we will see. I cannot give much deeper comment on that because I've not been following everything that's going on to the side of this case because it's quite a lot. And I've tried to view this case through as neutral a lens as we can when we came into trial one without knowing about these witnesses, without knowing the stuff that was going on. Because I wanted to try to see it as best I could the way the jury would see it. And there is so much outside this case that is known. It can change your opinion when a person sits down and testifies without seeing them before. When I appreciated that going into Depp Heard, I didn't have much of an opinion of the parties going in until we heard their testimony. And as their testimony went on, I went, woo, well then, here we are. So I looked at this the same way. Some witnesses I didn't think much of, some witnesses I very much like. It just depends on how it goes. I will have stronger opinions going into the second trial because we watched the first trial, not because of everything else going on to the side. So all of you that have outside info, I'm not telling you you shouldn't. I'm not telling you not to. I'm just telling you what my approach was with this and how I want to look at this case and continue to look at this case. So Charmander said, does that mean you won't talk about the juror interview? If there was an interview with a juror, again, I have been sick all weekend, so I am behind on everything except sleep. That is what I did. If there's a juror interview, I will take a look at it and we'll see. If I know there's a Karen Reed interview, I will take a look at it and we will see. All right. Let's continue on. Let's continue on. Oh, my lip stain traveled. It's not supposed to travel. It just is what it is. Let's continue on. Let's put the court back up. I'll stop looking at myself and let's go on.
Between the defendant attorneys and Ms. Voss, I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me.
And this should be just
It was
easy.
sent to a transcriber, but I told the transcriber not to listen to it or record it. Because,
We covered this already.
Although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach.
Again, I appreciate that the Commonwealth is bringing this forward with Your Honor. And this is the motion that we're on now. Your Honor, there is a protective order for the interview with Gretchen Voss for the non-disseminated portions of the interview. And that protective order says attorneys only. But we need to distribute this interview to a paralegal or a court reporter to transcribe it. We need others to have access to it. But because there's a protective order that says attorney's eyes only, we need the court to modify that protective order to allow the trial team to prepare it. That's what he's asking for. This is pro forma. It's easy to have. It's easy, and that's appropriate. And I think that him asking the court to update the protective order is 100% what needs to happen, but the court will update it. It won't be a problem.
So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay. There's no objection to this, is there?
No, Your Honor.
Of course, I'll provide a copy.
This could have been done on the papers. This could have been an
Alright,
email.
So this is allowed.
Yeah. That could have been an email. That is a very common and normal request.
All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Travers and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants' Rule 14 and 17 motion for court order authorizing defense access to the Lexus and Travers and to the driveway at One Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today, and today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us, and I would ask that the court take no action on this motion until we've had a chance to view them, and we may not need to have action
Oh, look at y'all getting along.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay.
That motion we covered last week. It was the defense saying we need access to the victim's vehicle. We need access to the driveway at One Meadows to take measurements. Apparently, the prosecution or the Commonwealth has done some 3D scanning and has just turned that over. I don't know when they did that 3D scanning. I imagine it was after the first trial, that because they hired a new accident reconstructionist and they said, we turned over the 3D scanning to the defense, and the defense said this 3D scanning might be enough and we might not need it. The O'Keefe family filed an affidavit. The court gave commentary on that, saying in the spirit of cooperation. So it might be, if you give us a heads up, you can have access to this. So they are asking for access to the victim's driveway area, the victim's vehicle, and more to the defense, more access to the defense vehicle. But it seems that that's going to be accommodated from the prior 3D scan. And again, everyone should be able to use those 3D scans if they're done in the regular course of business and if they are done in the regular practice. So if there is a regular practice for 3D scans amongst reconstructionists, which I'm sure there is, if those are done that way, then anyone can take that base information and use it the way they need to.
All right, so no action taken.
So that is going to be put on hold.
So the next is paper 493, defendant's motion to reconsider reciprocal discovery order and
I'm very interested in this motion. The motion regarding reciprocal discovery is something I am very curious about.
paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay.
I am
I'll hear
curious.
you.
Hey, Yannetti. It's been a minute.
Would you like me to address both issues first, or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has.
I hate that they don't just focus on the speaker. I really wish they would just focus on the speaker. I can't state that strongly enough, but I wanted to pause because Leslie said, is Lally no longer on the case? Lally is still sitting there at counsel table. Lally seems to effectively be benched from speaking in court. He is still sitting there, but he has not done any of the arguments. And for those of you asking about the reciprocal discovery, this is a motion I covered last week. I'll just give a quick. The defense is arguing that they shouldn't have to turn over impeachment information that is not witness interviews per se, but impeaching information, photographs, videos, data, social media posts, until they are going to use it, which would mean after a witness testified, if it's solely for impeachment. So that's part of what this argument is about. I covered it, it's timestamped, but I covered it last week. It's an odd thing to me, and it's hard for me to wrap my head around because it's so different from how trial practice went. Different jurisdictions do things differently. I saw a comment yesterday on QuickBits, I think it was, where a paralegal from another jurisdiction is like, letter filings in New York, what are these letters? And I'm like, I know. It's so strange. They do letters before they do motions. It's just a different thing. And I don't mean strange as judgment. I mean strange as different from the way we're used to practicing. And the law, though similar, is practiced very differently across the country. So the reciprocal discovery, as I am used to it, is that when your witness is done testifying, if there is something for impeachment only, it gets turned over then. It's like, oh, by the way, there's this thing. It doesn't get turned over in advance. And the defense argument was, this allows the Commonwealth to then go to the witness and say, hey, do you know about this thing? And they can go, oh, I forgot that, or oh shit, you caught me. And then deal with it before they testify. And that can be an issue. So that's what they're arguing about now, is when they are going to turn that over. For all of you in the chat saying, Lally's been rehomed, kind of. So let us continue. I hope they head back to the speaker. It's my preference to not focus on the victim's family.
Discretion in this area with regard to discovery orders and reciprocal discovery orders.
This is an odd practice to me.
I'm also aware of the court's ruling in the first trial, whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider.
It's weird.
It is our position.
I think it's strategically wise to have Yannetti arguing this, because if Jackson argued this, the court would, I think, this is again me speculating, I think the court would default to, well, this is the way we do it here, Mr. Jackson, because it's very clear there's times that the court looks at Jackson and is like, well, this is how we do it. If any of you were watching the trial in California, oh God, my brain is going to blank. There were multiple times where Attorney Lewin was looking at the defense going, well, here in California, because the defense attorney was from New York. And attorneys very much try to home turf one another with the ASAP Rocky case. Thank you, Megan, in the chat. My brain, we're still sick. But there's a lot of times where it's like, well, that might be how you prefer it, but that's not how we do it here. So having the local attorney argue is very wise, because again, attorneys will big time each other in court in all kinds of different ways. And I know you don't practice here, but this is how we do it is very common. KCLS is pro hoc vice normal. It's incredibly normal in civil cases. It's less common in criminal cases, just because criminal is much more specific. But pro hoc vice in civil cases is incredibly normal. And pro hoc vice means really for this case only, like, hey, Your Honor, I don't practice in this jurisdiction regularly. I'm not bar licensed here, but I'm in good standing in my jurisdiction. And I've got a buddy, and my buddy lawyer will make sure that I don't like fuck shit up. So my buddy lawyer is going to take responsibility for me and make sure that I follow the local rules. And then we can work on this together. It's incredibly common. It's different in criminal. In high profile criminal, like this is, we're starting to see it more. But you need a local attorney who knows the judges, the courts, the jurors. An attorney from California isn't going to look at where a juror is coming from and have a sense of who that juror might be or what their community is like, versus an attorney who is local. Even attorneys from elsewhere in the state might not know the local jurors well, especially in larger states. A juror from Boston and a juror from Canton and a juror from, wherever else in Massachusetts, Holyoke or Amherst might all have very different vibes as a juror. And so you need lawyers who understand the localities differently. And that's important. All right. So now we're getting back to when are we turning stuff over?
Judge, that
I'm going to small-in myself,
and I believe I
want to eat some breakfast.
On the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency.
And we
in
heard
their
all of this in the
testimony.
motions that we covered.
With regard to
There were a couple
Ms. McCabe,
There were a
it was
couple
never mentioned
issues
anywhere
they
that
gave.
she spent an hour at the home,
Examples.
personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data which revealed that that meeting did take place.
And by geofence, I imagine
the
they mean
Commonwealth,
Life
armed
360.
with that information.
I wanted to see so much more Life 360 data. Like, I wanted to see all of it. Like, give me all of the Life 360. No, we didn't get it.
Went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. Secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that
These are
video
the
of
examples
the steak tips
that were in
incident,
the
and
filings.
It clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed, so I take responsibility for everything that's in there. But we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was.
I disagree with this. I thought this was an overreach. I still think it's an overreach without more information. Also, Trooper Proctor may not have been subject to the same sequestration of witnesses because Trooper Proctor was the investigating officer. Trooper Proctor would have done all the interviews, read all the reports, and had access to everything. So it's not the same when we're getting to an investigating officer. So I think this was a bit of a reach. I imagine that because this is a bit of a reach, this is what the Commonwealth will focus on in responding. But we'll see. We didn't see a written response by the Commonwealth. It seems they submit those the same day that they hear them. So we'll hear it in argument. This was a bit of a reach. But when you have these things that are a reach, it allows the Commonwealth to focus on that and not focus on the other points that are valid, because this one was too much. And Proctor can watch the closings. Anyone can watch the closings. If a witness wanted to watch the closings at home, they could, because the sequestration order is over by then. So this is an overreach, but the others might not be. I think there was room for restraint in this. I also think that they just wanted to put in that Proctor was calling everybody a dick. Let me know. I think they just wanted to put in the motion again that Proctor's calling AJ a dick. I mean, you guys, this is going to shock some of you. I'm being sarcastic. Jackson can be a dick. All of these attorneys can be a dick. Attorneys can be dicks. It's part of the job. Sometimes attorneys choose to be a dick. And I'm using dick in a gender neutral way. Attorneys can be a dick. Shocking. Be shocked. Be shocked. If you piss off AJ, he is going to go ham on stuff. But yeah, attorneys will act like dicks. Sometimes they just do it for fun because they're bored. Do you know what would be great? Just traitors, but attorneys that have been on high profile cases. Oh my God. Can you imagine like Ben Chu and AJ and Camille Vasquez and Erlinda Johnson and Spyro? Oh my God. Can you imagine? Can you imagine? Can you imagine? Someone make it happen. Someone make it happen. Someone make it happen. I need traitors, but just lawyers. Let's go. Okay, let's continue on. Be shocked. Attorneys can be dicks. And putting it in a motion that Proctor thinks that AJ's a dick makes Proctor's day. Makes AJ's day. All right, let's keep going. I'll pitch it. Don't worry. It would be so good. It would be so fucking good. Like, lawyers don't want to do physical challenges on like Survivor or like Deal or No Deal Island, which Boston Rob has now made me obsessed with, but traitors? Yup.
Was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. You know, if we turn over this information in advance, not only
Erlinda
does
would win
the
traitors for sure.
Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information. But, you know, this is I won't say.
And then they can make somebody spout the rule of perpetuities as a challenge. Oh my God. Who can accurately recite the rule against perpetuities? Well, their hand is in like a box full of creepy crawlies. Oh my God. It would be so good. It would be so good. Oh my God. Poot would be hilarious. There's just Elaine. Yes. It's your favorites and your love to hates. Oh my God, it would be so good.
It's a unique trial, but it's a rare trial that, you know, is streamed online. There's obviously a lot of press interest. Some people are watching.
Hi, we're streaming online.
Everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, you know, it's another opportunity for a witness to see potentially
I
in
appreciate
advance
this argument.
something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
Rotten Board would have to be in there too.
Understood.
I need to find the motion for
so-
sanctions.
Mr. Brennan?
I think that's probably impounded. Because I haven't seen it. Oh, no,
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor.
my paper doesn't want to work, which is the only thing about digital papers. Sometimes my paper doesn't want to work. Right now, my paper doesn't want to work. We've now just written an entire treatment for a TV show, which I'm here for. What if anything is for breakfast this morning? Who, if anyone, was killed by the traitors last night? Can you imagine? I can imagine it. All right, let's see if the paper's back. So the argument from the defense is that the reciprocal discovery is being forced to be turned over too early. I appreciate that Brennan is coming in with the reciprocal discovery shouldn't be forced. That's reasonable. It's reasonable. I don't always like Brennan's arguments, but this, at this point, seems reasonable.
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A,
They are?
1A.
Making a note of that.
That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for
Right.
example, if the Commonwealth is going to call an expert, they have to provide.
It sounds like some of the rules of discovery are updating March 1st. That doesn't surprise me. It happens really frequently. It's why we all do continuing legal education. That the rules update, and normally the update starts in January and then goes into effect some period of time later. So it doesn't surprise me that the updates are going into effect March 1st. I'll take a look and see what we can find. They're not, Massachusetts, it's not part of my continuing legal education that I'm still finishing up with because it's my reporting year, but I am finishing up my own, but I can take a look at those and see. So let's continue on with the defense reciprocal discovery is different than the Commonwealth reciprocal discovery. They are different rules.
Provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything.
True.
If the Commonwealth is not going to call a witness, they still have obligations.
True.
And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call. They need to produce it to the defense.
True.
For example, I get random emails from unknown people, anonymous, or sometimes their names on them.
Don't do that. Don't do that. Internet. I'm not talking to law nerds. Law nerds, no. Internet. Don't internet at cases. People try to insert themselves into cases. It's going to make things difficult going forward. If you're not involved, you're not involved.
Them talking about theories of the case. I give it to the defense.
I'm sure the defense gets the
Because in
same
my
emails.
possession, custody, or control, I have no intention of calling an anonymous person, but because I have the
Sarah
information,
Boone
because
did.
I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it.
What about
And
impeachment?
so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice.
Impeachment has rules.
There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to.
And yes, chat, I caught it when he said it wasn't adhered to. They didn't turn over video until midway through the trial. I hear you. I hear you. I know. I hear you. If I pause every single time I have to yell at them, we're not going to get anywhere. But the defense didn't adhere to it. Well, did the Commonwealth, Brennan? Boo-boo. Inverted video. I don't like surprise evidence popping up in the middle of trial. I don't care what side does it. I don't like it. Impeachment is different, though, than evidence you intend to use. The thing is, in most of these rules, they say evidence you intend to use. And California interprets this differently. Massachusetts might say, if that witness testifies, then you intend to use it. In California, they say, well, you don't intend to use it unless this witness says A, B, and C, and you need to impeach them. So you're not intending to use it. It's a backup. So different jurisdictions will interpret this differently.
It will be trial.
I just wish we could watch Brennan talk.
And so since there is no caveat or exception for the defense, and
I
since
couldn't
there's no
control my
entitlement
face
to
with these
withhold
arguments.
material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
That's rich.
Okay. Was there any follow-up to that? The motion for sanctions will be a little.
But Brennan, you too, though. You too, though.
A bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial.
We know,
I never want
Brennan.
that to happen. Sometimes exceptions happen on both sides.
Brennan, Your Honor, I have been burdened as a defense attorney with late discovery from the Commonwealth, and oh, the horrors. Brennan, you're still on this side right now, dude. You chose this. You tapped yourself in. You volunteered as tribute. So you get the I'm mixing analogies. You get the shit sandwich that was already prepared, which was a lot of stuff that came up during trial. I don't know if that's stuff that Lally was unaware of. I don't know if the investigators that work within the DA's office just popped things at Lally and were just like, surprise, or if he knew. I don't know. I don't know if it was a lack of diligence, if it was malicious, if it was law enforcement, if it was Lally. I don't know. But, okay, let's just keep going. We're never going to get through this hearing today.
The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you.
The judge. All right.
Next is paper 495. This is defendant's motion to...
There are times where I am put out by the judges. Emily, I say I'm going to stop pausing, Emily. Also not done yet. There are times where I'm put out by the judge's demeanor. All of us are. But there's also times when it's dead ass. And right there with Brennan being like, rah, 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 and the court's like, all right. Yes. All right, let's see what the next motion is.
Compel discovery, and then there was a response from the...
Emily, back up. You talked too much.
Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Miss Little, I like your pointer finger ring. I love a pointer finger ring. I really
Your
do.
Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
Excuse me, Attorney Little. Ma'am, we've talked much about Jackson's beard, but we have not taken time today to appreciate your waves. I, for one, appreciate the waves. Look, my poor hair needs a haircut like nobody's business. I'm living for the waves. I'm living for the waves. They are fantastic. Attorney Little, I don't know how you do this in the winter, but the hair is hairing and I love it. My hair in the winter is like, you get what you get and you don't get upset. So we're living for it. Love it.
So, I'm sorry, before you do, so you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or?
Yes, of course,
Okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th.
It's a very normal request.
As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage.
Weird.
Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have...
Miss Little, I'm going to let you
surveillance
finish. A lot of you have asked, and yes, I linked it on Amazon. Today, it is the Sugar Fresh Berry Lip Balm. That is what we are wearing today. For those of you that have asked, yes, I linked it on Amazon so you could easily find it. Yes, you can find it elsewhere. That is what it is. It is a lip balm. It is berry. I dig this color. That is what it is. So that's what we're doing. Berry colored lips are my vibe. So that's what it is. Thank you for asking. Let us continue. Miss Little, apologies, ma'am. Let us continue.
Footage from outside the Canton Police Department where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. only report or documentation associated with any of those 3 productions is a singular report.
Also, I need to make a formal apology to my Remarkable. It was user error. It was not that it wasn't working. It was that I had selected the wrong color ink and I wasn't working. Apologies.
From
It was
July
me.
of
I'm the
2024
problem.
that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information.
How are we allowing
don't know
evidence
who
in
the
that has no
custodian
chain of
records is
custody?
with regards to those
How is that evidence?
productions, or how this information magically appeared in the Massachusetts State Police
I love
and
the
Norfolk County
one of the
DA's
mods will
possession.
post
We
the
are
Amazon
entitled
link.
to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an
Angie beat
obligation
me
to
too.
create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take
The video feed did pause. The audio is still going. So we're going to continue on with it until the video unpauses, but it'll unpause in a minute, I'm sure.
ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize.
I'm not
First
surprised.
responding
We're
officer,
here.
Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Garino. Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey. All of these individuals
We heard
are
all this in the
material
motion.
and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications.
Also, yes, the video does keep buffering. It got a lessee for a second there, but it's not you. So for those of you listening in the background, do not worry. You can hear just fine. The video is stuttering a little bit. It happens.
Associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation.
That's fair.
Concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case.
If
which,
they're
again,
witnesses in this case, yes.
deals with the clearing of a fellow officer.
Right.
And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino,
Hold on, I'm turning on my
the
heater.
same person who obtained and
You can see how
analyzed
good the back of my sweatshirt
electronic
is.
devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship.
Some text messages, 30,000. Excuse me. Some text messages, 30,000 text messages.
With Sandra Birchmore, no evidence of improper conduct, nothing to see here.
30,000.
When the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was a cadet in the Stoughton Explorers program. They detail.
For those of you that don't know the Birchmore case, I covered it very briefly when the federal indictment came down for Farwell on the Emily Show podcast, which gave an overview of what that indictment was, and then talked briefly about some of the witnesses that are interconnected to this case. The reason it's coming up is because there was a federal investigation into Birchmore. The federal investigation then charged Farwell, who is the officer that the department had cleared. This was dealing not only with Canton PD, but also dealing with Massachusetts State Police and some similar witnesses here. The defense is saying, look, we need unredacted reports because this is impeachment for these witnesses. There is a federal investigation that has uncovered a tremendous amount of information showing that these officers either willfully lied or at a minimum looked the other way aggressively. So they want the unredacted reports from the Birchmore case with regard to officers that are common to this case. They don't need all of it. They don't need everything, but they do need it as it's related to witnesses that overlap. That case is horrific. If you look into it, it is incredibly sad, but my overview of it does not get into every single sordid detail. I really try to overview cases so that you can understand the legal import of them without covering what the headlines tend to cover, which is all of the awful things. There's plenty of awful things in the Birchmore case, and you can that indictment is public. There's lots of coverage of it. But if you want an overview of the case, I have an overview of the case for you on the Emily Show podcast. We'll link it. It's an infuriating case. It really is an infuriating case. So she's going to get into it a little bit, but I've got it covered on the podcast.
Violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects.
Yep.
As to request
Agreed.
number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that
So
information.
if it's Rule
I think that's fair.
17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right.
Chad, if you're going to ask me what a Weenus motion is, you are not going to get a serious answer from me today. I apologize. It's going to be coming from case law regarding Rule 17, but the defense has argued that there is an ongoing order for that.
Somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its—
Your Honor, he doesn't like it so much when we do it, Your Honor. He wants to make these requests all day long, but when we turn around and do it, he's like, oh, no, I don't want to do that.
Agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
All right, that's the defense motion.
All right. Mr. Brennan.
That's the defense motion for discovery. Rule 17, Rule 14. We went over that motion again. We spent way too long. I mean, we spent as long as needed. It just takes as much time as it takes. We spent a lot of time going over these motions last week. And so we covered them last week, but it is, Your Honor, there are some things the Commonwealth agrees to, some things they don't. I imagine we're going to hear Brennan object to just what he's objecting to, but there needs to be reciprocal discovery. And I think the Birchmore redactions are going to be the biggest argument here. Let's hear what the Commonwealth has to say.
It's important to represent facts accurately.
Facts.
And the court has ordered in the past.
It is, Brennan. It is. We stand for facts. And sometimes we enjoy the fuckery. And when we enjoy the fuckery, we at least don't represent fuckery as facts. We just say, this is fuckery. Away we go. But yes, facts are important.
Asked when representations have been made that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense.
Oh, that motion is coming on the 21st, Brennan. Don't put the cart before the horse here, sir.
As to number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them.
If there's no chain of custody, isn't that the problem, though? Your Honor, if there was chain of custody, we would turn it over. Isn't that the issue, that there's no chain of custody? Like, chain of custody is baseline. Who touched the shit? I argue a chain of custody when somebody eats the donut at my house. It's often my oldest. Who last touched the bag of donuts? Who saw the bag of donuts? Did anyone ask if the donuts were theirs to eat? I want to know. Chain of custody. Who touched it? That's all. Who touched it? Anyone work in an office where chain of custody over food in the fridge becomes the central focal point of your office? Like probably pre-2020, right? Where chain of custody of food becomes the entire focus of an office. Right, chain of custody, it matters. There were donuts. There were donuts. There are no longer donuts. Chain of custody matters.
I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to.
I want to know who touched them.
But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have.
That's the problem.
It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto.
I did not hear this is not going the direction that my brain thinks it's. What? If they're the same witnesses in the two cases, then it's impeachment. If a tech expert, let's just go with one. If a tech expert downloaded a phone and say missed 30,000+ text messages that were deeply damaging to an individual, and that tech expert is the tech expert in your case, that's information that needs to be turned over. I don't think it's an implication that there's a problem. I think it's a direct statement that there's a problem, because that's a problem. Where are we?
It's important during argument to mention that there's an ongoing federal investigation.
We know.
And then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing.
Nefarious is what broke my brain this time. Let's just clear two things up. One, the Birchmore case, there was an ongoing federal investigation that resulted in a federal indictment of a law enforcement officer. I believe he was state police. It's been a minute since I've looked, but I believe he is state police. First. Second, there is in fact an ongoing federal investigation into this case. And it seems that that investigation is not into Karen Reed. Based on everything that we've seen, it seems that Reed is not the target of that investigation. Maybe she is. Maybe I'm reading the situation improperly, but maybe I continue to read it correctly. It does not seem that Reed is the target there. So there are two ongoing. Thank you, chat. I'm going to pronounce Stoughton wrong, Stoughton, but yes, Farwell was Stoughton. Thank you. And Canton and MSP helped out with that. Appreciate you. Chat's the best. Real time. So there were multiple federal investigations, and there's probably others. Let's continue.
List a number of witnesses for the Commonwealth. And find
Nefarious.
somehow something's nefarious. That these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists.
There are times that the defense reaches in this case, of course. That is their job. They are the defense. But having unredacted information with regard to common witnesses is not a reach for me. It might be a reach as we get to Michael Morrissey, but even then, maybe not, depending on what it is. But to parasite onto the case, Chad, I'm going to let him keep going and see if we get to code red yet. He is using all of the language, but it's a bit much.
It's easy to throw out a name and attach it to the Birchmore case. Troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it.
Same
a factual basis, a good
tech
faith
expert.
basis. We hear
They're
the
common
defense say
witnesses.
that Trooper Guarino says nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here.
That's because it's not verbatim.
I don't know what report they're speaking about when they suggest Trooper.
I do. And I'm only watching this on the internet and reading half of the motions that we get that aren't impounded. Trooper Guarino said that they didn't find any deleted messages on Jen McCabe's phone. That Trooper Guarino is like the like heart of some of these arguments. And as to Trooper Guarino, though, they are well taken. Trooper Guarino said, I didn't see this, I didn't see that, I didn't note that.
Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis.
I mean, either
to use
wrong or
compelled
incompetent,
discovery on a case
they get
that
to
has
argue it.
nothing to do with Miss Reed's case. They just say it. And so you should reject outright.
Your Honor, the defense is just saying shit. Brennan, where's the legal argument, though? The defense is just saying shit for the media. Sometimes they do. With regard to Trooper Guarino, this is not the thing. Now is, oh boy.
An argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience.
Ew.
And so the reality is the Birchmore case is being investigated by federal authorities.
It's been indicted.
There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case.
I disagree.
Birchmore was a victim.
Yes, that's facts.
Number 4. Unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case?
Guarino.
Troopers work on many cases. That case certainly has a...
And if they fuck up on one case, that information can be used in another case. See, that gets turned over.
public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing.
Wrong.
But invoking it is helpful for the defense. So they do.
You're just
You should reject it
ignoring the
outright,
point. I reject you outright at this moment, Brennan. You're ignoring the point,
Number
sir.
5, all communications, documents.
If you're going to be a prosecutor, you need to at least argue beyond just saying shit. Your Honor, they're just saying shit as you're sitting here just saying shit. You're also just saying shit. And you've ignored Trooper Greeno entirely.
Reports, memorandum.
And if that's all been redacted, then say it. Just say everything with regard to Trooper Greeno has been unsealed and turned over. Just say it.
And regarding Trooper Proctor administrative proceedings.
I want to
Any
hear about this.
information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information.
Okay.
In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing.
Look, there are times that this dude pisses me off. That is a stand-up thing to do that is not within his obligation. So I'm going to point out the things that don't piss me off as much as I point out the things that piss me off. I realize me being pissed off is way more entertaining. I totally get it. But he said, and we're going to catch this real quick because he's going to scoot right past it, I imagine. He said the defense has asked for a phone call with the attorneys for the board that is doing the hearings with regard to Trooper Proctor. That is not within the possession and control of the Commonwealth. It's not. So he said, I will be on that call. Anything that's going on in the sealed proceedings, the disciplinary proceedings with Proctor, should be turned over, and I will be on that call to advocate for that as well. Here's the crux of that is going to be interesting, is that normally that information does not get turned over until it's resolved. Because if somebody is absolved of wrongdoing, then the result gets turned over, not this. So there has been much questions amongst the chat and others about whether or not the state police are drawing out that disciplinary proceeding until after trial starts. I understand the concern. I'm not going to tell you I'm unconcerned, but normally those things don't get turned over until it resolves. The court can ask for more, but it's not within the possession of the Commonwealth if it's in the possession of state police. Let's continue on.
Duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law.
Yep.
I can only earnestly try to my best of my ability.
And state police is going to say no dice. That's what's going to happen.
I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham. The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses.
You're just reading your email?
First, Karen Reed.
Okay.
All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the
tend to diminish credibility. That's what the defense was just arguing with regard to Trooper Greeno and with regard to everything in the Birchmore. Tends to diminish credibility. That's what they're looking for.
Truthfulness and the integrity of the investigation, or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith.
He
to the
asked for them.
Commonwealth and the defense.
He did ask for them.
So
I
we
asked.
are and have made best efforts to provide all of that material.
Fair.
The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue.
The court can yell at them. The court can yell at them. Let the court yell at them then. Your Honor, why don't you yell at them? I have seen judges say, oh, they don't want to turn it over? Bring them in. Let's have an in-camera. Let them sit in chambers and explain it to me why they can't turn it over. The court has more power here to get that turned over, and everything with regard to Proctor, I think should be turned over. There is going to be some fighting over, and this fighting is not the Commonwealth's fight, and this is the Commonwealth bowing out. The Commonwealth has said, we've asked them to turn it over. The Commonwealth is going to let state police lawyers fight it out with the judge. Your Honor, you fight it out with state police. We said turn it over. We think you need to turn it over. Turn it over. But we're going to let you deal with it. And I think that's the exact right thing for the Commonwealth to do. And it's difficult when agencies don't want to turn stuff over. We see this in Idaho, where there's been fighting with what the is going to turn over. And we've seen this in other cases when you're dealing with local jurisdictions and federal jurisdictions. Sometimes the feds are like, we'll get to you.
To abide by our obligation and duty.
So. My chair is fighting with me.
Number 6 and 7, we do not object. Number 8, there is a difference between ARCCA, and we'll discuss that in more detail when we get to the
I want to talk about ARCCA.
The ARCCA motion and expert discovery. We have provided, there is a difference between ARCCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would
that's work product.
reduce
That's
it
fair.
to writing and I would provide it to them. They have all the materials
just don't
our
trust
experts
you.
relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one.
It's generally not done.
And has any relevance whatsoever. It is different for ARCCA, and again, I'll delve into that when we talk about ARCCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law
Magnolia Rose, I disagree briefly. I don't agree with a lot of Brennan's arguments. I don't always agree with the way he makes them. Brennan is a very good attorney. I don't always agree with what he's arguing, but Brennan has been much more on top of things than Lally was and is putting up a fight. I don't always agree with what he's fighting, but he is a good attorney. Oh, y'all are annoyed by his voice. Okay, that's fair enough. That's fair enough. If y'all are going to spoil, just know that they'll get deleted. I know we're behind time. The law nerds choose to watch with me. I am never on time. So thank you all again for no spoilers. All of you are like, no, his voice, I can't listen to him. That's fair. That's fair. All right, let us continue. But Brennan is coming at this from a different perspective. But again, he chose this. So.
enforcement in any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me.
He's still receiving discovery, which is wild. It doesn't shock me, but it's wild.
Me for Rule 14 materials and provide it.
Okay.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement.
First of all, Alessi is a mood for me today. He's got what looks like a remarkable, maybe it is, maybe it isn't. It could be an iPad, but it looks like a remarkable on the table. And then a pack of Halls, the exact same pack of Halls that is sitting in my dining room right now. Yes. Alessi is me in court. Everything is, Alessi's a vibe. Emily, do you enjoy Alessi? Yes, sometimes I think he reaches, but I enjoy him. He amuses me. All of the tabs, the Halls, and his e-writer. It's just a vibe. All right, we're going to get on to the next motion here. Let's see what it is.
Do you have that Rule 17 paper number?
Alessi's turn of phrase is great.
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
can
over
use that.
500 at this point.
They're going to be
Yes.
working on it.
All right.
When they're talking about paper number, docket number, they're not just looking for the date it's filed. The public system in Massachusetts is so hard to navigate. The federal system, for all of its flaws, the docketing system is so easy to navigate. The paper comes in, it gets docket numbered. This is numbering. So they are trying to look for the docket number of that prior item that they're looking for.
All right, so next we'll move on to the so-called ARCCA motion.
ARCCA!
Commonwealth Motion to exclude employees of ARCCA, paper 497, and the opposition 505. So, Mr. Brennan?
Okay. Remember, the ARCCA motion, just give us real quick. The ARCCA motion from the defense is not a motion saying they're not experts. It's a motion saying that the defense hasn't turned over the necessary discovery. So this is a discovery motion. And when the judge is reading the titles, remember, she reads it as the attorneys type it. So if the attorneys type it with shade, the judge reads it with shade. But the ARCCA experts, and it's because they are called ARCCA because that is the company that they work for. So this is Brennan's motion to exclude based on his argument that there are discovery issues. And he has said throughout the motions, it's not that the defense hasn't turned over discovery. It's that the defense cannot produce discovery because the feds haven't given the discovery to the defense because these experts were not hired by the defense. They were hired for the federal grand jury, not the defense, not the prosecution, which I found their testimony to be very interesting and impactful. Let us continue. I'm very curious to see what happens here. So Brennan's going to argue first, and then I imagine Jackson.
Sure.
I thought they were fascinating experts. Brennan should have just stayed up there. It's like, one of the things I will say I appreciate about the judge in Idaho is the judge in Idaho listed out the order of the motions they were going, and there wasn't as much ping-ponging back and forth, but it is what it is.
Your Honor, my purpose is not to deprive the defense of an expert
It's just these experts.
or deprive the defense of an ARCCA expert in this case.
The defense could hire them.
But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's
The
collaboration
feds have done that.
between one side or the other. in that expert witness that they don't know about and can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now,
Lally backed down on this pretty fast.
Trial, but I've read the transcripts.
He's not backing down.
On June 10, 2024, you asked the defense about ARCCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial.
That was
could
true.
not prep with us for trial.
That was the court's
ruling.
ruling.
Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here.
Yes.
And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their...
Jackson was like, let's ride, motherfuckers. We got it. All Jackson had going into the first trial was the transcripts from the federal grand jury. And for Jackson, that was enough. He's like, mount up, let's go.
Testimony and their background, we've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor.
That's true. I remember this.
So you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed, and over a long period of time with requests and deadlines, I finally received a response that was unresponsive.
The feds.
And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves.
Right.
A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required.
Okay.
Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
What date was that?
They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now,
Yeah, this seems like
It's not the
before
opinion.
trial. This
That troubles
seems like before trial, last trial. Offered, you guys said he said March 22nd, 2024. Great.
me. It's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Oh, boy.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, two requests, and...
So, oh, boy. Oh, boy. Well, I don't know if we're code red yet, but what Alan said to the court was, hey, we only discussed scheduling. The feds turned over emails that are showing that Alan and the experts are having conversations beyond scheduling. That's not good at all. All right, I'm going to back up because I want to hear the date of the first one. I'm sorry, chat, that we're going to go over this twice, but that's not good. That's not good at all. So let's continue. I'm going to back up because I want to hear that date of that email because the dates are going to be important.
Is that there are conversations between the defense, Attorney Jackson,
I backed up a little bit.
and Daniel Wolf, who's one of these ARCCA witnesses.
Look,
thank you so much for taking...
with everything in court, y'all, we're going to wait and see. We're going to wait and see. So, no spoilers, please, chat. Thank you. Thank you, moderators. If your comment gets deleted, it's because the mods see it as spoilish. No spoilers. Thank you.
Taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith along with your retainer as required.
That's not odd to me. So the defense tried to hire the ARCCA experts and the Fed said no. Okay.
The Commonwealth, as I understand it, was not aware of any promised rewards or inducements
It seems that wasn't made.
or payment. They relied on a reciprocal discovery order of this court.
Right.
For
It
that
seems
information.
that wasn't made.
Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
So they spoke after the voir
Now, this
dire.
isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, two requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline,
if the experts are sending Jackson an outline of what the questions should be on direct examination, that is witness preparation. That's witness preparation. And if the court had said there is to be no communications, and that's what the court said, there is to be no communications between these experts except for voir dire, and there's preparation, that's not good at all.
Is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says,
Brennan, I'm just going to say, if you have the smoke, the commentary is not necessary, because he keeps quipping. And if he keeps doing this at trial, he's going to piss people off. He keeps quipping with this fair-minded objective expert. The snark. If you have the smoke, the snark isn't needed.
so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated.
Was it an attachment to an email? It's not dated. Could that have happened after the trial then? Because if it's not dated, could it have been a conversation after the trial? It could have been.
The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines
You know who's going to know the date? Jackson.
the conclusions of ARCCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case.
It doesn't necessarily show bias. What it shows to me is communication. And they said there was no communication. There might have been communication since the end of the last trial till now. So I'm going to wait and see. But it definitely shows communication. It doesn't show that they were hired. And TUI requests from the feds are so difficult. But these communications could have been since trial. The language of it indicates it's during trial, need to show the jury. That implies that it's ongoing during trial. But if the feds are turning it over, then there should be dates. But Fed TUI requests are like, here's some shit. I understand the Commonwealth's frustration. And if Jackson said, no, we've never had a conversation, and these emails show that he did, that's also a problem. It doesn't necessarily mean there's a bias, but it does mean that there was communication where no communication is what was represented. And that's shady.
Case.
So we'll
Then
see.
this. Another comment.
Oh,
Would be
let's
fair
hear
to
'em.
say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty.
That's a problem. That's going to be interesting if they testify again.
It certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to
This
say
is
because you
interesting.
had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area
True.
of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine.
Yikes. Yikes. That's communication between those experts before he testifies. Oh, boy.
That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925.
That needed to be disclosed.
That's not Tramble.
When is that bill from? Because if ARCCA was paid, that has to be disclosed. That's a huge problem. This seems to be, and hopefully the defense will clear this up, this seems to be between voir dire and testimony, but the court said no communication and no prep with these experts. If there was voir dire and then communication and then testimony, that still needed to be turned over. There is a requirement for reciprocal ongoing discovery. Just like if the Commonwealth had conversations with the witness after testimony, which they shouldn't have, it's hard to think of an analogous circumstance that's not completely improper. But if a witness hadn't been called to testify yet and the Commonwealth had a conversation with them before they went on the stand and they said, oh, by the way, I remembered this thing, the Commonwealth has to go to the defense and say, before this witness testifies, you need to know that they just disclosed to me XYZ. And then if between the voir dire and the testimony, there were additional witness statements, those additional witness statements need to be turned over.
That's not trial by ambush.
And if there's payment,
That's
that needs to be
getting
turned over.
So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works.
Okay.
And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens.
Yeah,
I don't
Brennan's
care if
pissed.
the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
They are
I'm gonna
entitled to
take a
discovery.
recess before the response.
Court, all rise, please.
Oh, the judges are going to be happy. Oh, the judges are going to be happy about that. The judge is taking a recess. Yikes. I'm going to zoom past the recess. I'm curious to see the rest of the response because, as we know, law is advocacy. So when one side is done arguing, you should be like, oh shit. And then when the other side argues, sometimes you still go, oh shit, or sometimes you go, that's wild. So it seems that we might have a defense discovery violation as well. So the judge is taking a recess. I'm sure the judge is pissed because if that happened in between voir dire and testimony, which is what it seems, do we know that for 100%? No, that's what it seems. If that happened between then, it had to be turned over to the Commonwealth. My cat's name is Karen is asking the most important question. What's the relief for that? There isn't any. For the Commonwealth, there isn't any. It gets turned over now. And then if they testify, they get hammered on cross. The Commonwealth has less options. They could sanction the defense, like asterisks, but there's been a lot of discovery shit in this case and nobody's been sanctioned yet. So just sanctioning the defense on this when other things haven't been sanctioned would seem a little imbalanced because there's been a lot of stuff. But yeah, for those of you saying Brennan's making a lot out of this, yeah, but this is a problem. If money changed hands, that has to be turned over. When an expert makes a statement like, oh, visibility with pedestrians, but we don't have to say that though, that needs to be turned over. Those types of statements need to be turned over. So the judge is taking a recess. Guess what? We get the only fan. We don't have the exact dates because of the way the feds turned it over. That's what Brennan says. AJ's going to know more. It looks like that is a long recess. Ooh, a long recess. Are we meditating? What are we doing? That's a long recess. All right. Let's get back to court. That's a long recess. The court needed a minute.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications.
Now you're gravely concerned? Anybody else anxious? Anyone else anxious? Anyone else anxious? You guys are like the court had bubble guts. Maybe. I'm anxious. Now there's grave concern? I'm going to let the judge speak. We might have to go back and look at what the defense represented, because the defense represented before voir dire, they hadn't spoken. I don't know if they re-represented that before these witnesses testified. I bet the judge went back and looked at the transcript. I would have.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Pissed.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
She's pissed. She's pissed.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything.
We have chat a lot of the time. You guys ask about people's breath. Adrenaline can change your tonality in your voice. If anyone's ever performed or been nervous or angry, she's pissed. Adrenaline. That's adrenaline. She is so fucking mad. I think I'm going to let her finish. We're going to back up and we're going to watch this again. We're going to do this twice. She's so mad. You guys are going to be mad, but I agree with the court here. I'm going to let the court finish and then I'll tell you why.
Would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now.
Oh, shit.
Less than a minute. The chronology is December 4th. We sent another tour request, 2020.
We're going to do this twice. I'll talk to you guys about why she's not letting the defense speak. She's fucking furious. We're going to do this twice. Hang on. We're going to go through it once and we're going to back up and do it again.
The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts.
I remember that.
And that if either party wanted to engage, the original materials are still protected.
Oh. I wonder if the contract ended with the ARCCA experts because of these communications.
This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was
The defense provided the emails? You did say it was the federal government.
defense, February 13th, 2020.
I'm backing up.
The defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the
So the defense sent you the emails and the outline.
federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
Little's like, no.
It would have to be at 9 o'clock.
All right. We are going to go back over what the defense is arguing, and then they are going to get to scheduling. We'll get to scheduling in a minute. We're not going to go to scheduling. Oh boy. I know a lot of you are frustrated. Hold on. I know a lot of you are frustrated. I get it. I don't think the judge is doing anything other than protecting the defense here. The judge is furious about things not turned over during the first trial. The defense has said that it is her opinion that this can have substantial consequence. And the court has said we are coming back in a week, which gives the defense time to prepare. Because this may or may not have impact on the defense. But because the court is so upset, and because what has come in, the court feels is significant, the court is saying, I am done for today, and we are going to come back. So instead of asking the defense to dig themselves out of a hole while the court is mad, I think she has done the right thing and said, I am calling a timeout for today, and I'm going to give the time to the defense to prepare to respond. That is a fair thing to do. If the court just wanted to flame the defense, she would say, explain it to me right now. The defense is being given time, and I think the court is also being given time to back up and review. This is a good timeout. I know it's frustrating. A judge that really just wanted to throw the hammer down on the defense would have said, stand up and explain it to me right now. Stand up and explain it. She is giving the defense time. That is fair to do. But this may be a very large deal. So I know it's frustrating that we are on a cliff at the moment. Like, this is the worst to be continued ever. The Bravo editors could never. It's just like, to be continued. You're like, what? So I know it's frustrating. The court is giving a broad swath to the defense to explain. This may be a bigger issue. This may be a misunderstanding. This may be a gray zone. It's my memory that when the ARCCA experts came in for voir dire, the court said you can't have conversation with these experts. And the defense said, we're bringing them in cold. It seems to me, based on what we've seen, that there was conversation with the ARCCA experts after voir dire before they testified. But it is the best of my memory that the court maintained that ruling that they could not prepare those witnesses outside of voir dire, which might be the issue here. But if that was not the ruling, and the court, I'm sure, is going to want to go back through and look at the exact rulings. If the court said nothing at the end of voir dire about whether they could communicate, this might be in the middle. So there are still questions here. It's not great. I have questions. But if the conversations were between voir dire and testimony, there might be an issue. There might be. But we need more info. It looks bad. Agreed. Agreed. But we need more dates. We need more info. Woo! And it's a lot of new information, and the court needs more information. The court's going to want to go back and look at exactly what was said and is going to need time to do that. So what we're going to do is go back and listen to what the defense thinks is their gotcha moment and then go forward. So this may be a code red. It may not. Ah!
Bruh.
I meant to bruh, and I was on the wrong page. I'm sorry. That's not what I meant. That's not what I meant. That's for me. But this may be a big deal. I'm interested to know more. So I think the judge is going to give herself a minute to go back and look at exactly what her ruling is. And I think that's fair. Let's go back and look at exactly what Brennan said. But we've got a lot of discovery issues. And here's the thing. This might not be just a discovery issue. This might be a violation of the court order. And that's a bit different when the court specifically orders something and the defense said, yes, we've adhered to the order. It seems that there might be a direct violation of the court's order, but we don't know yet. Priya Patel in the chat said, Emily, this whole case is an issue. That's fair. That's fair. The fuckery does not cease. The fuckery does not cease. So I'm going to go back. We're going to look at what Brennan had to say again. And then we're going to talk about the potential options here. This might have a very big impact. It might have a reasonable explanation. It might be a violation of the court's order. It might be a gray zone in the court's order. But what we do know is that next week is going to be fucking fire. That's what we do know. What if it was after trial? If it was after trial, I don't think we're, I hope I pronounced Noof correctly. If it's after trial, this is not as big of an issue. But this seems to be during trial. This seems to be during trial. This was all after the trial. If it was after the trial, that's different. But these seem to be contemporaneous between voir dire and testimony. If these are before this next trial, it's different. So let's go back and read again. If Brennan is misrepresenting the situation, then that's going to hit back at Brennan for sure. Let's damn it, Emily, that's probably copyrighted. Let's go back and see what Brennan had to say before the break. The court also, I think, needs more information, and the court is mad. So the court's like, nah, I'm giving myself a minute. So I want to hear what Brennan has to say about these emails with the ARCCA experts. I hate that we're on a cliffhanger. But I want to hear what else he has to say. By the time I get to Quick Bits next week, I'll probably have more thoughts about it. So we'll get there. So let's go back. Doodle-a-doo, doodle-a-doo, doodle-a-doo. Let's go back and see what was turned over and see look, all of the attorneys are going to make mountains out of molehills. But oh my God, this is interesting. Again, it looks bad, but we don't have all the information. And so I try to stay away from that other than saying that looks bad, but we need more information. So thank you all for knowing that it's really hard. It's really hard to wait. I can't believe the judge is like, we'll come back next week. Damn it. I want answers now. Your Honor. Now. Damn it. I mean, the list of things I want. We're not going to go through them at the moment. I want to level up on Midas Merge. It's just not happening. All right. I want Boston Rob back on Traders because, God damn it, having to spend an episode listening to Tom Sandoval go, nya, nya, made me want to yeet my television out the window. I also want the promised 6 inches of snow that we're supposed to get, and I feel like we're going to be disappointed. They're going to tell us it's 6 inches, and then we're going to get like 2, and it's going to be like, I was lied to again. Let's go back and see what Brennan had to say. Emily, stop making jokes about the snow. And then we'll get to Q&A since court is done in a shocking fashion. All right.
And it was striking that it wasn't noted as unresponsive, just when I read the materials. And
we are jumping back in time, doodle-doo, 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 back in time to listen to what Brennan has to say about the defense conversations with the ARCCA experts.
Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials...
All right, I think I need to back up a little. I'm going to back up just a little bit more.
So that the experts could testify. If the defense is going to be a proponent.
Because again, here's what I appreciate in Brennan parsing this. Brennan is saying, I'm not saying that ARCCA can't testify. Brennan's argument has always been, we need the discovery. And if the defense is a proponent of the expert, we're entitled to the discovery. So you can't halvesy it. You can't have it both ways. You can't say this isn't our expert if it's really your expert. If it's really your expert, then you need really your expert. Brent Woodchick, I appreciate this. I want more inches. I want more than 2. Well, 2's enough to kind of shut things down. Also, my kid's sick. Can school just be closed another day or 2 so that he can get better and not miss any more school? Because damn it, this season, we have missed so much school. I'm ready. For those of you north of Nashville, I know. TDOT's not going to get it clear. I know. It's not. I'm ready for a few snow days. So what the Commonwealth is arguing is, look, you can bring your expert, but if you bring your expert, I need the discovery. And if this isn't your expert, I still need the discovery. But it seems like this is kind of your expert because you are chatting. So, Raven, I appreciate it. I definitely have thoughts on this case. But we'll call out lawyer fuckery on all sides. And if there's lawyer fuckery, we'll call it out. I don't know if there's lawyer fuckery. So we'll see. I have thoughts about this case for sure after seeing the first trial. But we're going to listen to Brennan's arguments again and see what we learn. Trial is supposed to start. The new trial is supposed to start April 1st. The last trial started May 2024. So those June conversations would have been during the last trial. Jules, if travel expenses were paid, that had to be disclosed. But I think I don't remember. If travel expenses were paid, it needed to be disclosed that they paid travel expenses. That might have been disclosed. It might have been brought up during the first trial, and I just don't remember. I don't remember everything. But guess what? We covered it, so we can go rewatch. It's on the internet. So we can find out between now and next week. All right, let's see. I'm going to let Brennan.
Do you have that? Wait, so.
Yes.
All right.
Brennan, I'm going to let you argue.
Exclude employees of ARCCA, paper 497, and the opposition.
We're listening to his whole argument.
505. So, Mr. Brennan? Sure.
All right. Brennan, I'm going to zoom you a little bit.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCCA expert in this case.
We're rewatching.
But there has to be a minimum requirement of reciprocal discovery and discovery
Agreed.
before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that
Also, I didn't disagree with that based on how it was presented last time. I can understand why the Commonwealth is mad about it, but the court said, this is my ruling, this is my remedy. But if the ruling wasn't adhered to, then there's problems. RS asked, can we watch AJ's statement after the hearing? If we can find it, we can watch it.
there is other things.
Team
that are
Baker's
relevant,
looking for
like
it.
Compensation, promise, reward, inducement. Whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken.
This is before the voir dire. And I think the timing is going to matter a lot in this. This is before the voir dire.
To them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined.
He's reading the transcript.
And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
This is from June
12 and 28/13 of June 10, 2024.
This is
Now,
before the
having
voir dire at trial.
Some familiarity with the federal government.
So this is before what he's reading from the transcript is the colloquy that happened before the voir dire of the ARCCA experts between the court and the defense from June 10th, 2024. That's what he just read. And the defense had said that they coordinated their testimony, which I took to mean coming to court to give testimony, and their background, but they had not interviewed them. Let's continue.
It seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
It's still funny to me.
So I filed the TUI letter, comprehensive TUI letter.
And filed it,
And
I
it
mean,
was delayed.
he gave it to the court.
And over a long period of time with requests and deadlines, I finally received a response that was unresponsive.
Shocking. The federal government gave you something that's unresponsive.
It was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there.
Excuse me, the trial's on YouTube, sir. Let us continue.
There's email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required.
Okay, they tried to hire them. Does them trying to hire them shock me? No. Let's keep going.
Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
It seems that didn't go
They
well.
relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move.
And that seems accurate. So here's where we're at. I'm going to keep breaking this down. We're in March 2024 before the last trial. The defense is aware of the ARCCA experts because they testified at the federal grand jury. It seems that the defense reached out and said, we would like to hire you. And the ARCCA expert said, per our conversation, send over a retainer and we can hire you. And then the AUSA has said, time out. You are our witnesses. There are some issues with you being the government's witnesses on the federal case and potentially being hired by the defense on the state case. We would like you to pause those communications. And it seems that the ARCCA experts reached out in March and said, the U.S. Attorney's Office had told us that we can't continue these conversations. So far, this isn't wild. Let's continue.
Move forward. Now, it's not the opinion that troubles me. It's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes,
This is what
Alan,
I'm worried
I spent some
about.
time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
This is what I have
Now,
concerns about. This is going to matter, and we need to run it back to what did the court say? And I do not know. This is from June 22nd, 2024. This is in between the voir dire and the trial. So this would be after the voir dire, before the testimony of the ARCCA experts. Because I think they testified that Monday or Tuesday. So this is in between the voir dire day of the ARCCA experts and the testimony of the ARCCA experts. And they're having communications with Alan Jackson. Any communications at that point should be turned over. So if there are communications happening in this window, they should be turned over. The question is, did the court order get violated, or is it a discovery violation? There are two questions here, because the court said you can't prep with these witnesses. That order should hold across the voir dire and the testimony. So this might be an issue. And just so we can clear it up, the Emma Mack, research attorney in the chat, I've just dubbed Emma Mack that. Many of you in the chat have pointed this out, and thank you to everyone who has. Voir dire day was the June 18th, and they testified on June 24th. The testimony was after the weekend. So this is in between, this June 22nd date is in between the voir dire day and the testimony day. This is potentially a problem. Do we know how much of a problem? I don't know. This is potentially a problem. So let's continue on. Figuring out, Casey said, but this was turned over. If it wasn't turned over on June 22nd, it's potentially a problem. It's turned over now, but it's potentially a violation of the court order then. It's turned over now. It doesn't stop it from being an issue then. If it was turned over then, that's different. If it wasn't turned over till now, that's different. So we'll see. If it was turned over then that's different.
Information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline
He said Sunday.
of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know.
I'm curious who provided an outline.
Fine.
For all of you asking the date of the email, this is from Sunday, June 22nd, 2024.
An outline of questions and answers for a direct examination.
Back this up.
And an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth.
Again, if the expert is sending the attorney a list of questions, that's a witness statement.
what follows from this outline
If that outline's in that
is
same
then
email, which it
the
might be.
outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says,
The commentary, though, Brennan.
so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the draft.
This is witness prep. Here's the issue. Is witness prep an issue? No. Is witness communication an issue? No. Is the findings from that expert something that would normally get turned over? Yes. Is the full detail of that conversation something that would always get turned over? Not always. Is this an issue because the defense told the court that they did not have conversations with these witnesses? Yes. Though I, to best of memory, believe that representation was made before the voir dire. So these conversations might be in a gray zone after the voir dire. These communications themselves are not an issue. The fact that these communications might be in violation of a court order is an issue. The fact that these conversations were represented to the court that they might not have happened may be an issue. Does that make sense? So this might be the gray zone in between the two, because the best of my memory is the defense represented before the voir dire that they didn't have a conversation with the witness, but there was also a court order saying you cannot prep these witnesses. Talking to the witnesses after might be an issue.
Direct examination, I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material.
Because this is witness
so
prep.
It wasn't necessary.
This is witness prep.
Need to show the jury it doesn't matter in this case.
The date of that?
It's not dated. It's not dated.
I think that was probably turned over with that email. Not dated is important. But if this happened in June, it might be a problem. If this happened after June, it might not be a problem. We'll see.
The TUI request is a recent February response, but they send random documents. There's no real accounting.
And then I think, based on what we heard after this, and again, a document contained as an attachment to an email, the document itself might not be dated, but if it's attached to an email, you can find the date of the email. It seems that he represents this is coming from a TUI request when this came from the defense, which he clarifies later. Because I imagine the defense was like, we turned that over.
Now, I'm not saying that undermines the conclusions of ARCCA. Or not.
There's
I'm not
discovery
saying they're not
issues here.
qualified witnesses, but it certainly shows some bias. I've turned over
It shows prep.
a lot less in this case than this.
Yeah,
Another
it's an
comment.
issue.
Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
But what is the date of that, Brennan?
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925.
When that bill is turned over and when that bill is for is important to me.
That's not Tramble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden.
That's also
and the
fair.
Commonwealth, like the defense, is entitled to discovery. So if they can produce the
You're
discovery,
gonna keep banging the table.
I'd welcome ARCCA.
All right, I'm going to take a recess before the response.
And the court's pissed. The court's right to take a recess. We're going to hear what the court has to say one more time. The court's right to take a recess when frustrated. We need more information. This might be a massive issue. This might not be a massive issue. This might be a violation, direct violation of the court's order. But we need the languaging of the court's order and we need the timing of everything because we need to know. And I saw Jessica W., your comment makes perfect sense. It was just in all caps, which is hard for me to read. If, and Jessica W. in the chat said the money was for hotels and flights. If the defense paid for ARCCA's hotels and flights, that has to be disclosed to the Commonwealth. That has to be disclosed. So if that wasn't disclosed, that can be a problem. I'm going to see what the court has to say again. Then we're going to get to questions. You guys have a lot of questions about this because the court's pissed. Is the court most pissed because it might be a violation of the court order? Yep. The court's mad. Mad.
Right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And
Brennan's going to say more. We're going to let Brennan say more.
The federal authorities have been kind enough in the past to allow me to have copies of everything. Would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of.
You guys,
if I could
I'll
add
get to
that right now,
questions.
it would take
I'll
me
get to
less than a
questions.
minute.
I'll get to
The
questions.
chronology
Don't
is
worry.
December 4th, we sent another tour request, 2024. January 6th,
Brennan's
we filed
not
our
done.
notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government.
He did say the federal government. So the February 13th emails, no. He was provided the emails on February 13th from the defense. Hold on. That was just a few days ago. So the defense provided those emails, but the emails are not dated. The original emails don't seem to be dated February 13th. It's when they were turned over. I'm going to back that up to hear it again.
From the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts.
Which is interesting.
And that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the The defense provided us the emails that I read, February 13th, 2020.
And that is a large correction, that those emails came from the defense, not from the feds.
I think I said the federal government.
You
It was
did say the
defense.
federal government.
February 13th, 2025, they sent us the emails and the direct examination outline.
So the defense sent the emails and the outline. The date of those emails is going to be very important. We're not going to probably know the date of all those emails until we get to the next part of this hearing next week, but it matters.
We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one
Move
day
it, move
to
it.
the 26th instead of the 25th?
Let's see if it's the 26th. I mean, I guess I'm here.
It would have to be at 9 o'clock in the morning.
Yelvin does not like to be up early. My schedule doesn't matter. There's also an Adelson hearing that day. The 25th, there's no other hearings. My schedule doesn't matter in this. I'm being hyperbolic, but you know. I'm going to try to see what date we get to.
Hand up the discovery that was
Thank you.
provided by the defendant reference card.
Oh boy.
Great, thank you.
I mean, if this is happening on the 26th,
We
sorry,
can do the
Donna.
afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
He's the one on blast. He's not going to be on Zoom. His ass is in the hot seat. He's not going to zoom in when this is about him.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
You're going to have to accommodate the court's
Are
calendar.
all parties available at 9 on the 26th?
I'm not.
May I have just a moment?
All right, we're going to get to scheduling issues. I've told you multiple times, I had a case with 11 defense attorneys in one part of the case and 3 defense attorneys in a different part of the case because it was in 2 different jurisdictions. Scheduling took half of our day. Scheduling 11 defense attorneys was like herding kittens without treats. It was a nightmare. All right. This feed is going to end because my amazing producer, Miguelina, told me that it cuts out before they finish scheduling. All of us want to know what the schedule is. So we're going to switch feeds real quick to make sure we get to the scheduling because we all need to know when we're coming back because I am deeply invested. Y'all are deeply invested. We're invested. So we need to know. We need to know. All right. So we switch feeds real quick to see when we're coming back to court.
All right. So we'll see everyone.
Your Honor, I'm sorry.
We're not done
Just on behalf
scheduling.
of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
Mr. Alessi's like, I came all the way down from, at least Alessi can take a train. I don't know if he does or not, but at least Alessi can take the train. And Alessi's the court's like, we're done. We're done. But at least Alessi can take a train. Jackson's got a bit more travels, but Jackson chose to be on this case too.
All right, 11 o'clock on the 25th.
Thank you.
11 o'clock on the 25th. Lawnards, that's a win for us. Lawnards, 11 a.m. on the 25th. Ha-ha. We're not going to be conflicting with Donna Adelson's bond bail hearing. For everybody who's like, Emily, are you covering XYZ case that has documents? No, we're just live court right now. 11 a.m. to 25:25 to continue this shit. Woo, baby. All right, let's let this roll through to the end real quick. Damn. Today got unexpectedly feisty. So that's 11 a.m. Eastern. That means I'll be around 10. Well, no, I won't. This is a day that Lawnards, make a note. Make a note. This is a day that will go down in infamy. This is a day that we're just going to be on time. We're just going to be on time. We have no choice. All right. That's the end of that feed. So let's see if there's anything else at the end of it. Nope. Nothing else at the end of it. All right. A number of you have said that Jackson made a statement. I haven't seen that. Emily's, no, you might not be able to be added because your handle is in all caps, but I can see you. And the chat can see you. All caps sometimes are hard with the username. So all caps can be difficult. All right. Damn, today was different. So that's a day that we're going to, well, with like a 15-minute window, that's a day we're going to have to be on time because damn, this is true. Stina, I will not be on time. We will be very close to time. But how glad were we for the Zoom room when the judge took like a 30-minute break today? I have never been more thankful that we had Zoom room because holy shit, today is crazy. I have not processed. All right. Let's try to do a summary. You guys are telling me there's filings. Let's try to do a summary. I'll go look and see if there are filings. Peppermint, thank you. The Lawnards are deeply invested in this one. So the cases that are getting ready to go to trial are taking priority over cases that aren't getting ready to go to trial. So cases that aren't getting ready to go to trial, in order of priority, kind of get booted a little bit. We might have to cover this tomorrow if there are more filings, because I'm not going to be able to process them in real time today. But I might wait and see what happens today. We were going to do something different tomorrow, but if there's a bunch of filings today, we will just cover them tomorrow. So do not worry. I will also note for those of you that love the hoodie today, look, it's got the Neuro Spicy on the back. This is my little favorite skull. It's so fun. These are still available in the Lawnard shop. For those of you that said there is stuff that was in the Lawnard shop that sold out and I am sad, yes, we sold out faster than I anticipated. Much faster than I anticipated. We are having meetings with Team Baker this week to try to figure it out. We will let you know. The merch that we sell we changed processes. We are now custom. Our merch is custom. Our hoodies are custom. So they take time. They are pre-ordered. They are not drop shipped. So they do not make them as orders come in, we make them in advance. So sometimes we make too much. Sometimes we don't make enough, but we will be looking at what you guys are requesting and see what we can do and let you know. But this spicy hoodie is still in the Lawnard shop. It is an oversized hoodie. So if you like oversized, get your normal size. If you do not want it to be oversized, downsize. It is an oversized hoodie. It is meant to be an oversized hoodie. I like this hoodie in a whole bunch of different sizes, but you can size up and size down. Take a look at the measurements because it is oversized. It's meant to be oversized. And if you want it to be oversized, that's great. So, we will do that. Carla, we are talking about doing a pre-order that will then get made after the pre-order. It's just going to have it's going to have a longer ship time, but it's on our list to discuss. So these hoodies that say oversized are in fact oversized. The zip-ups are truer to size. Oversized is oversized. The zip-ups are true to size. So the hoodies are still there. Sparkling rutabaga, the hoodies are still there. The zippers sold out very quick. So we are talking about what a pre-order would look like. Bright Eyes, we did tumblers. We do not have a new tumbler in the queue, but we will talk about it. Let's try to do a summary. Then I'm going to try to answer all your questions. If I do not know something, I will tell you. Some of this, we're going to have to wait and see how it shakes out. We really are going to have to wait to see how it shakes out. All right, let's try to summarize because, geez, today. Lord, there's not enough lip gloss. There's not enough lip gloss. Oh, the zipper ones. Some of the zipper ones, did all the zipper ones sell out? Some of the zips, the I have question zip sold out faster than we anticipated. We really try to do, to closely, our goal is that people can get what they want. But I think these zip ups are the black on black spicy zip ups are still there. But we have meetings. We have meetings this week. Do not fear. There are meetings this week to talk about it. Okay. Today is just. What in the world? Let's do a summary and then let's just answer all the questions. And then we might just need to cover this tomorrow. If there's new filings, I'll cover them tomorrow. And then we will push off what we were going to do tomorrow till later in the week. Unless there was court tomorrow that I've forgotten about. It's possible. It's possible. But if there's more filings today, I'll grab them and we'll just cover them tomorrow. Like look, you can only ride, one horse. Or no, that's not the accurate quote. Emily, the correct quote is, you can't ride two horses with one ass. Sugar bean. So if there are lots of things we will ride, we will ride this. This is our one horse, one ass. I have not seen video of the AJ interview. If you guys saw it on video, I've seen just a statement on Twitter, but I have not seen a video. So if there's a video, let me know. But can't ride two horses with one ass. This is the horse we are on. We're on this horse for the moment. So we might cover it tomorrow. And then on Thursday, we'll cover what we're covering later. Okay, summary. Summary. Let's do that. I'm trying to summarize in my brain. Today was a lot. That's the summary. Done. I'm teasing. Let's try it. We'll see how it goes. Well, today was unexpected. When we got through some of the motions, the court called a timeout on the hearing today and continued it to next week. So we are not through everything because the court said, nope, we're stopping right here and we are going to resume 11 a.m. Eastern, February 25th, 2025. Why? Well, as they were arguing over the ARCCA experts, remember, we referred to them on the channel as the crash daddies. They made a cannon to shoot glasses into a Lexus taillight to see if that replicated the smash pattern. They talked about whether or not John O'Keefe was hit by a vehicle, whether or not they could reconstruct the accident. They were the experts who testified in the federal grand jury proceedings, who were hired and retained by the FBI and the U.S. Attorney's Office. Remember, when that went to trial, Lally, at that point for the Commonwealth, argued that they had no discovery regarding these witnesses, and there was a court order that said the parties weren't allowed to talk to the witnesses. Then we had a colloquy that was read back in court today by special Prosecutor Brennan that said, so defense, you're telling me and I am summarizing, this is not verbatim. You're telling me that you are bringing in witnesses that you have not spoken with. And the defense said, yes, we have the discovery turned over by the feds. They had the federal grand jury transcripts so they could see their prior testimony. So it isn't like they didn't know anything. And they had not prepped them. And the court said the solution to that was a voir dire. And then there was a full day where the court allowed for the ARCCA experts to be questioned outside the presence of the jury before they testified before the jury. The defense made a motion to exclude the No, wrong, Emily. The Commonwealth made a motion to exclude the ARCCA experts based on discovery, saying that the defense did not turn over all of the reciprocal discovery regarding those experts to the Commonwealth, and said that if the defense can't turn over the necessary expert discovery, then these experts can't testify. And that's where we picked up today on that motion. Brennan saying, look, I'm not saying that the ARCCA experts shouldn't testify. I'm saying they can't testify without reciprocal discovery, and the discovery we've been turned over so far is troubling. And then Brennan got into a number of emails that he said initially were turned over by the feds, and then corrected himself and said they were turned over by the defense. Those emails seem to indicate that there was ongoing communication between the ARCCA experts and the defense after the voir dire and before the testimony. There was also an email where the defense seems to have offered to hire the ARCCA experts, and the Fed said, please cease that line of communication. It also seems that there was an invoice from the ARCCA experts to the defense for somewhere around $23,000. The chat asked whether that could be for travel expenses. It doesn't really matter what the expenses are for. If the defense paid ARCCA anything and that was not disclosed, that should have been disclosed during trial. It was after that recitation of information from the Commonwealth that the court took almost a 30-minute break, came back out and said that she was deeply concerned and that this information might have large ramifications or repercussions for the defense and the defense attorneys, and then stopped the hearing for today, saying that when we resume on the 25th, everyone can be prepared. There was much frustration over the court ceasing the hearing today, but it is my perspective, and I know many of you won't agree, and that's fair. It is my perspective that this was the proper thing for the court to do if the court thinks that this is a big deal, to give the defense time to prepare their response to this and to more fully vet the timeline. I suspect that the court will go back and look at what the orders were with regard to when you can talk to the ARCCA experts. It seems that some of those communications were in between the voir dire and the testimony. So if it's just a discovery violation, that's going to be different than if it's a violation of the court order, which is going to be different. When was this discovered? When was it turned over? When did these communications happen? All of that is going to matter to determine how big of a deal this is. There have been a lot of discovery violations in this case, a lot of them from the Commonwealth. So if it's a discovery violation, it's different. If it's a violation of a direct court order, that can be different. But I'm sure the court is going to want to go look exactly at the language of the court order regarding conversation with those experts and look at what the defense said on the record. So I imagine the court's going to go back to the transcripts and even ask Brennan, what about the transcripts? If that was made more of in court by Brennan, the court's not going to be happy about that either. So I think we will see the court taking a beat to allow the defense time to prepare and respond. It sucks for Alessi, who came down from New York to argue his motions today, and we didn't even get to them. But the court was like, this is a problem, and we need to take a look. Whether it's a violation of a court order, whether it's a violation of discovery, we will see. But I think the court pausing to give the defense time and to take a step back and be prepared for this is appropriate to do. Frustrating, yes. Appropriate, also, yes. It might be made more of by Brennan. It might be a bigger deal. But the defense would not be the only party in this case that has had discovery violations. But if the defense represented to the court that they had no preparation with these witnesses, these emails seem to indicate that there was some communication and prep with these witnesses in between the voir dire and the testimony. So when did the defense make that representation? Before voir dire, or did they represent it again after voir dire? And the court and the Commonwealth and the defense, and I'm sure the internet, are all going to go look at those things. Other things that happened in court today are completely overshadowed by the dramatic ending of the hearing midway through. We didn't get to all of the pending motions. We didn't even get to the motion that I was really interested in, which was the defense motion from Alessi to exclude the Commonwealth expert. I really wanted to hear what was going to happen because it seemed like the court ruling on that one was pretty clear that the non-doctor witness can't give medical opinion. I wanted to know where we were going with that, but no, cut off, absolutely. So this may or may not be a big deal. I am sure in the next week there is going to be much speculation over it. I am going to wait to see what papers are filed in court. I may also go back with y'all on stream to take a look at what was said on those days, and I've linked them down below because we have those days. But there's also going to be things that happen at sidebar that we don't know that will probably come into these motions. If there are more filings between now and the next court date, I will go over them. So we will see if this is a big something or if this is something that was made to look like a big something and really isn't as big as it seems. But yes, there have been discovery violations on both sides, it seems. And yes, there is still a motion to dismiss that the defense is filing on the 21st. And yes, this case is going to continue to heat up ahead of the retrial on April 1st. And surprisingly, we've got Karen Reed giving an interview to the media. I have not had a chance to watch it yet. I've been sick. But Karen Reed giving an interview. It seems that a juror has come forward. Jurors have given statements to the press. There's a lot more information about this case outside of court that might impact how this case goes forward in a month and a half. This is not going to slow down. So the other motions in court, the court ruled on a very few of them that were no objection. And then there was quite a lot of objection, non-objection, but non-objection. Brennan saying, Your Honor, I'm not objecting, but you need to know about whether or not the defense would get to bring in another attorney. And we heard argument about that in court today too. Will the defense be allowed to bring in another attorney pro hoc vice, which means in this case only, who also represents Aidan Kearney, who is known around the internet as Turtle Boy, who has been covering this case. And there are separate litigations going on to the side of this case there. And the Commonwealth made a lot of notes to the court. Your Honor, it's not an objection, but you should be aware. And so that pro hoc vice is going to also be litigated. We'll see if it gets litigated on the 25th, but we're going to have to take a look at that. And that's over whether or not Attorney Betterow will be able to join the Commonwealth. Or not the Commonwealth. Emily, wrong! Whether or not Betterow will be able to join the defense team. And I imagine the Commonwealth will also bring up statements, if statements have been made that attorney made outside of court. Again, that attorney was not part of the case with regard to Karen Reed before this, so they're allowed to give comment on the case. But we'll see what the Commonwealth has to say as notes to the court that aren't objections, but kind of are. But again, if you're not the attorney on the case, you can give comment on a case. So when you become an attorney on the case, then there are different rules that apply. Today was a lot. It was not the longest hearing that we've seen on this case, but it was a spicy one for sure. All right, law nerds, we'll be back in court on this case on the 25th, but I will be covering any filings between now and there because there's going to be some fallout on stream. So get the Law Nerd app so you know when we are ready to go. Get the Law Nerd app so that you know when we're starting. And let's go to questions because I know you all have lots of them because damn, I've got questions too. We're not going to have all the answers today, but at least we can answer some of them. Today has been a lot. If I didn't say the 25th, I meant the 25th. I was just answering, I have not seen the Jackson interview. We don't have it. So I haven't seen what channel it's on. I have not seen it anywhere. So I don't know. I saw a statement on Twitter. I can go to a statement on Twitter. But that's all I saw was a statement on Twitter. So I can go to a statement on Twitter. Let me take a look real quick and make sure I've got the full statement on Twitter from Christina Rex's Twitter. That's all I saw. Let me see. I'm going to go find what was said because I don't see an interview. I see a statement on Twitter. The statement on Twitter from Christina Rex is, I asked Alan Jackson outside of court if he paid ARCCA experts to testify at trial number 1. He said, no, of course not. He might have paid their travel, though. That's not the most specific question. No, of course not. In court, prosecutor Hank Brennan read documents and alleged a bill from ARCCA to the defense of $23,000. There might have been a bill. Was the bill paid? I don't know if the bill was paid. It might have been. It might not have been. So let's see. I see a lot of you asking about watching a juror interview. I'm not going to do that today. We are at 3.5 hours and I am still sick. But I will take the motion under advisement. We have lots of filings that we're going to have to get to tomorrow. If we need, I will probably summarize a juror interview. I will go take a look. I haven't watched it yet. Again, you guys, I slept literally all weekend. Scott is saying it's on Fox 25. Miguelina, will you just take a look? So we will see. Anita asked, does Court TV pay royalties to the defendants? Not to my knowledge. And I don't think there's any mechanism for them to do that. But I am still under the weather. So will I take a look? Yes. Will I stream snipe somebody's interview? Probably not. But will I summarize and maybe highlight? Maybe. And then the Boston 25 interview is with Karen Reed, and I haven't watched that yet either. Again, sick. I've been sick. So I am trying to maintain the ability to stream this week without completely just like, and I am just but the one of me. So there is only so much, but I will take a look. I will take a look at it. So we will see. Let's do Q&A. Kathy said, what are you afraid of? If you were talking to me, what I am afraid of is getting pneumonia on top of being sick as fuck. That's what I'm afraid of. That's the deepest fear is that that's what it is. I just have not had time. So, because sick. All right. For those of you saying Fox 25 had the interview that aired yesterday. Okay, not Jackson from today. I'll go take a look. But again, I can only do so much. And it is that time of year where we're trying to stay not sick. What are the new motions that were just filed today? I don't know. I haven't gone and looked at the docket. I've been streaming, but I'll pull them. We'll probably just cover Karen Reed tomorrow. So let's cover your questions and then we're going to rest. That's what we're going to do. Because again, balance, all things in balance. We'll get to it. Kadora 1090. Thank you for the super chat. Got permission from my speed building teacher to use EDB live as dictation drills. I'm officially halfway through court reporting school. Live chat and the law nerds have been huge encouragers. All right, we're claps to that. Just claps to that. Claps to that in the chat. Also, I will say, Alan Jackson speaks like at California trial speed, which is faster than some of the attorneys elsewhere in the country. California speaking like New York tends to be very quick. Brennan talks a bit slower. Leslie talks a bit slower. Jackson and Yannetti are pretty fast. It's tough. Anu in the chat, I see your member chat. I am so sorry about the passing of your mom. I'm glad you're here with the community. I can only imagine how tough it is walking that with lots and lots of friends. We haven't, I don't know. Their grief is miserable. It just really is. And it begets other grief. So we feel you. We're here for you. It is hard. It is very, very hard. Mannix said if Karen Reed is found guilty, but the feds determined fuckery, would that eventually negate the verdict? I hate to lawyer this answer because it really depends on too many different factors to give you a definitive answer. But if Karen Reed is found guilty and then there was some resolution of the feds, then that can be grounds for appeal, amongst other things, depending on the circumstance. So it really, really, really does just depend. Music to My Soul said, EDB, a recording of the Hear Yous might need to be added. They might need to be. We have a bunch of things I keep meaning to add to the soundboard, and I am so behind on work. I am just so behind on work. So you guys, we will keep looking for the Jackson interview, and we will loop it into whatever's on the docket for tomorrow. So do not worry about that. Vamp Face said, all hail the only fan. The Lawnards missed you. I mean, I missed you guys too from Friday to today. I hope you all had a good day off yesterday. Diana said, miss the Lawnards. I had a health scare, but I'm okay. I'm back. Glad you're back. Just purchased the oversized sweater. It is so cozy. These are the softest hoodies to ever exist. They are also a lighter weight hoodie. They are not going to be running out in the snow hoodies unless you are from the Arctic North and you're like, we laugh at 30 degrees. If there's not a negative before the temperature, we go lightweight. But they are lightweight enough that you can kind of wear them anywhere. Diana, thank you for the gifted memberships, and everyone who gifted memberships, thank you. KW in the chat, happy, happy, happy birthday. Lima, judge is pissed now, only now. I think there's other times that the judge has been pissed, but these are big allegations, and I think it's fair of the court to say, I need more information. I need more information. So I think that's fair. Let's see. Crash Daddy Wolf said, in my testimony, so part of this is after the trial, Melanie, or after the voir dire, because voir dire also counts as testimony, or after grand jury, because grand jury also counts as testimony. I get it. I don't think I'm downplaying it. Truly. I think there's more information needed, but also I'm not going to say this is the biggest deal in the world until I know more, so I can give you a fact-based determination. So if you would like me to just hyperbolically jump up and down and lose my mind, it's not going to happen, and you're going to be disappointed. I need more information. And I've said repeatedly, though I realize when people want me to pick a side, that's not satisfactory. But I've said repeatedly, this may be a big deal. This may not be a big deal. We need to know a few more things before we know. Because again, it's going to depend on what was said and when. And the court clearly needs to take a beat and go back and look at the court order. So is this a discovery issue? Is this a violation of a court order? Did the defense misrepresent things directly to the court? Did Brennan misrepresent things directly to the court? We need to know. So that's what we're waiting for. It might be a big deal. And it's hard to say, hey, Hazen asked, if it's a big deal, what can we expect to see happen? We need to know. Could you lose pro hoc vice? Maybe. That would be a very extreme remedy. Could there be sanctions? Yes. That's not as extreme of a remedy. That's more likely if there's a violation of a court order. Could we wait to see what happens and then give you a better assessment? Probably. But yes, there could be consequences if you misled to the court directly. That could be a bigger consequence, and it's something you can lose pro hoc vice status over. That is a drastic remedy. It's a drastic remedy. So with it being a drastic remedy, it's unlikely that if you haven't had sanctions before, that you're going to get to yeeting an attorney off. So we'll see. Is it on Brennan to find out those dates before presenting it? He represented the date of the email and gave the court the packet. So it's my presumption, I might be wrong. It's my presumption that everything that was attached was turned over by the defense to the Commonwealth, and that the defense will clarify those dates in their motion. We just don't have enough info. What happens if it comes out that Brennan materially misrepresented things to the court? Then Brennan's going to catch the smoke. Brennan saying this came from the feds and then saying, no, this came from the defense means that both sides have been turning things over. But we need more information. So it's frustrating not to have the answers. It's frustrating to wait. It's frustrating to finish book 3 in a series and have to wait 2 years for the next book to come out. I get it. I hate it too. But I also know that I don't have enough information to tell you how bad it is. Because I don't. I need more. And Katie Fisher said, I'm worried Hank misrepresented, and I don't know if he misrepresented anything beyond the basis of the emails, and he did correct that. Attorneys misspeaking and lying to the court are different. He corrected it on the record before court was over today, which was needed. AJ being off the case is a very, very severe sanction. And it would surprise me. Given everything else that's happened in this case, it seems that there are some other remedies that would come first. And Ballet Girl points out, can we just get to the case being thrown out? There are still discovery issues that may be Brady issues that haven't been addressed yet. And so there are issues on both sides of this that are issues. There are discovery issues on both. So we need to wait and see. Does it look bad? Yes. Can lawyers make a lot of things look bad? Yes. Did the defense try to make other things look bad in the hearing today that I said were a reach? Yes. Is this a reach on the Commonwealth's end? We'll see. We'll see. I'm not certain of when those conversations took place, and I'm not certain of exactly what the court order was. But will I look at that before we talk tomorrow? Yes. Yes, I will. Because this is not great at all. But again, look, the thing that we do know is if there's metadata for anything, it's at least the date an email was sent. If there's no other metadata in this case, the date an email is sent, we will know. Because damn, today was a lot. Today was a lot. Let's see. Doesn't the motion to dismiss due Friday? The motion to dismiss is due on the 21st. Is that Friday? What day is it? That's Friday. The motion to dismiss is due Friday. The hearing on the motion to dismiss is the first week of March. So the hearing on the motion to dismiss is either March 4th or 5th. So the Commonwealth has time to respond to that. So we're not going to get to the motion to dismiss until the beginning of March. We're going to get to this next week. So again, we will see. Joy, thank you. Your perspective is so helpful. Thank you. Anne said, as Arthur Weasley says, the truth will out. It's frustrating to wait. It is. But there is a lot that needs to happen, and we will see. And I agree. Karen said a bill isn't the same as payment. I agree. But if there is an agreement, the defense will cover any expenses, even if they're not paying them. That should have come up. I'm not saying that it didn't come up in the first trial. It may have. That the defense covered our expenses. It might have come up in testimony. I don't know that it didn't, but if the defense covered expenses, it should have been disclosed. It might have been disclosed. I don't remember trial one well enough for that. Megan asked what I'm sure a lot of you are thinking. Could this be an excuse not to throw out the case? They should not be connected. Any Brady violations on the part of the Commonwealth aren't tit for tat with anything that the defense may or may not have done. So those two things will be evaluated separately. I saw a lot of you ask, isn't this the Baldwin case? Not necessarily. We are in a completely different jurisdiction with different case law. The standard for violations in New Mexico discovered during trial are incredibly friendly to the defense. And in that case, the court had found prior violations. I have not seen anywhere where this court has found prior Brady violations. In New Mexico, the court had found prior Brady violations before that issue during trial. And the standard for during trial versus after trial is different. That might seem, contradictory. But the standard after trial is different. And there can be Brady violations here that don't require the case to be dismissed. Both things can happen. It is the more unusual circumstance that a violation causes a case to get dismissed. It doesn't mean that's the right result always, but they are different. And because this is ahead of trial 2, there are times for there to be other remedies. Those remedies can include, evidence being kept out of trial. That can happen. That might be the right remedy. Because if evidence is kept out of trial, it might fix the solution. Like, hey, you didn't turn it over, you don't get to use it. So that might be right. Has something like this ever happened to you in trial? Not quite like this. I mean, I've had shit go sideways in trials, but not like this. So this is a lot. Also, you often don't find out what's going on with the defense during trial. I've never seen a case. I've never seen a case that has a federal investigation ongoing while a state level trial is ongoing. It's wild. That circumstance alone is causing problems. It is incredibly unique. It is incredibly different. It's wild. So that circumstance alone is a problem. Oftentimes, if we had late discovery issues at the LADA's office, it was often the case where cases would either get delayed or dismissed to remedy it, depending on what the circumstance was. But the DAs would do that. So if a DA didn't know of something and law enforcement is like, oh, by the way, here's this thing. And you're like, motherfucker, I've asked you if there were additional reports a million fucking times. Now all of a sudden they're gonna, great. Great. Thanks. Lovely. It depends on where the case is about how it can be remedied. Sometimes the DA would dismiss the thing and be like, this should have been turned over. It wasn't. We're dismissing the case. You don't have to fight with us on it. We're pissed off too. Sometimes it would be this case isn't going to trial for another 8 months. There's time to remedy it. It just depends. My kid's personal Uber driver said, why is there a federal case going on? I still don't understand that. We don't have enough information to understand that. We have speculation. But it seems that there are multiple federal investigations going on to cases in Massachusetts. The Birchmore case is the one that we've seen a result on. So we will see what happens. It's a very, very unique circumstance. And this case has a lot of temperature being turned up on it. It's just wild. So, it's a very unique circumstance. So I think that it's likely the feds are looking into the investigation more than the feds are looking into whether or not Karen Reed hit John O'Keefe. Why do I speculate that? That is me speculating. Why do I speculate that? Because there's no reason for the feds to look into whether or not there is a hit and run in Massachusetts. It's not within their jurisdiction. It doesn't fall within their jurisdiction. It's not the kind of case that they take on. It wouldn't make any sense. But issues with a investigation, that is much more the type of things that the feds will look into, like in the Birchmore case. So that's why. Let's see. Victoria asked, is it an issue appeal-wise for Karen that the retrial is going forward when the federal investigation is still in the works? No. Does it not affect the situation at all? It doesn't affect the situation at all. It could affect it down the road, but right now it doesn't. The first trial went forward with the looming federal investigation, and it's still going on. So it's a lot. It's a lot. Squid, I didn't see a juror interview. I know there was one, but Squid asked, since the juror came out, can anything be done about the jury ignoring the instructions they were given? No. No. Connie asked, how does a pretrial Brady violation differ from after the trial took place? This is difficult in this circumstance because we're kind of in both. It's going to depend on the jurisdiction, and it's going to depend on if there's an adequate remedy. The law in New Mexico is very defendant friendly, and the court had already found prior Brady violations. I don't think the court has found prior Brady violations here. Smurf Anna said, my teen is on her first drive by herself. I am not okay. Smurf Anna, I know. I'm just going to tell you, I'm here for you. The first few times is stressful, but then it's glorious. My kid has helped run and pick things up at the P.O. box. My kid has helped run to the grocery store. It's been fantastic. So it's scary at first, and then it's glorious. The hardest thing about having a teen driver for me is I do not trust anyone else on the road at all. And it's stressful. And there's only so much you can do. Trust your teen, trust that their car is safe, and just tell them to text when they leave. That's my best advice. I'm still working through it. And I have a teen that really in his soul wants to be a race car driver. So I did my best and I gave him a Ford Explorer. My kid's like, I want a Nissan Supra. I'm like, you're adorable. You're getting something with 4 cylinders. I'm teasing. The Explorer has slightly more than 4 cylinders. But I do not ascribe to the train of thought that I love my teen. I love my teen. I do not think you should get your dream car at 16. First, you have to have something to aspire to. Second, God damn is car insurance expensive for a teen. And third, you're parking in a parking lot with other teens. You're not getting a brand new car. Some of the cars these teens are driving is ridiculous. That was true when I was a teen. I grew up in a bougie ass area, but my bougie ass area, kids were driving like new Jettas. It wasn't what it is now. It wasn't kids driving like luxury vehicles. The luxury vehicles were like, oh my God, they got a brand new Jetta. Amazing. No, I come from the hand-me-down school of thought. Hand-me-down cars. That's where I'm at. You have to work towards it. You have to work towards the car you want to drive. And then I'm going to teach you how to buy used cars well, because that shit depreciates in value so fucking fast. So my kid wants a cute car. I'm sorry. I live in an area that has all kinds of shit on the road. It is not California. California had people running across the road. Tennessee has less people running across the road, but like deer and armadillo and skunks. All the things. All the things. So, though lots of teens get new cars, and I pass no judgment, it is not the right choice for me and my teen. Maybe upon graduating from college, but even then, upon graduating from college, would my kid get a used car? Probably, and maybe like help with rent. I don't know. There are other things to spend money on than giving a 16-year-old a car. For me. So you're getting a car you're not going to fuck up. And that Explorer is one of those cars. All right, we're going to do a few more chats and then we're going to roll. So, Charlene, it's good to see you in the chat. Charlene said my friend totaled her car by hitting a moose in Wyoming. Thank goodness she's okay, but the car was unrecognizable. Yeah, you're not winning a fight with a moose. And thank God they were okay. Look, you just need airbags. You need airbags. You need airbags. Fluffy BBQ, a 10-10. Our kids get better at driving. Elderly parents get worse. I drive when I'm with my parents. I love my parents. I drive when I'm with my parents. Yep. Now, if I can get my teen to drive my parents, none of them are going to want anything to do with that. My parents are going to be like, fuck no. Also, when I started driving, I got a 78 Volvo. It was a freaking land tank. So, and the only thing I hit in it was my dad's Volvo trying to parallel park. And I didn't do it too well and ended up like bumping down the side of his car. Like, nope. I learned. He was not pleased. But I hit his Volvo with my Volvo. But goddamn, that thing was a land tank. It was great. Also, I didn't get punked at school by people picking up my car and moving it. Is that a thing my water polo team did to kids? Yes. They would pick up their cars and move them. If your car is small enough to be picked up by a high school water polo team, it might end up where you didn't intend for it to be. Back when kids would actually like prank each other. The memes that resonate with me so much are back in my day. We had so many eggs and so much toilet paper. We would take them to the home. It often says the home of our enemies, but that's not necessarily true. Because a lot of the times when we were out toilet papering and egging houses, it was not necessarily our enemies. It was those whose attention we deeply desired, because our water polo team would, and our swim team would, we'll get into this on a members only live stream, but we would basically play like capture the flag, but with toilet paper, and see if we could get to toilet paper the guys on the swim team before they could find us. And then if they could toilet paper our houses. So there was like a defensive position, and then there was like an offensive position, and the girls swim team and the boys swim team would go out and see how many houses they could get toilet papered before the opposite team caught you. And it was a whole thing. Was it the best? Yes. Did we have so much fun? Yes. Did mayhem ensue? Yes. Do I wish our kids could have such easy memories without a bunch of people calling the police and being like, there's kids running around. They've got squirt guns. Look, if the worst thing a bunch of teens are doing are toilet papering each other's houses and then catching each other with hoses and squirt guns, it was wholesome good fun. It was so much fun. But there would be defensive positions. And so if they caught you, you would end up just getting drenched. It was good times. But then again, going to high school in the 90s was different. It was just different. There's a asterisk on that story that we'll talk about on Members Only Live, which I think we're doing tomorrow, by the way, members. It's going, keep an eye out. It just is going to depend on how I'm feeling. If I feel like absolute crap, it's going to get bumped to next week. Did we clean it up? Generally the next day. Did the inside of my house get toilet papered once? Yes, that's another story. Hazen, thank you. Thank you for the super chat. Thanks to this case, Sandra Birchmore will get justice. Hazen said they are interconnected, like it or not. They are interconnected. I'm very curious to see down the road which case started the investigations. But yes, there is lots of information because of both cases. Amara said he said the defense, is implying impropriety, but Brennan was implying better of impropriety. Yes. Yep. Yes. So let's see. Mama Bear said, question, I wanted to give Brennan a chance. Alas, hyperbole. Lots of hyperbole and very unhelpful side commentary. There's lots of snark. It doesn't feel earned. Let me know what you think in the chat. Some of it is, not all of it. Can Jackson move for exclusion of the taillight pieces because of lack of chain of custody? Yes. We'll see if that happens, but yes, we will see. Yolanda, thank you for the gifted memberships. Much appreciated. Janice had just got my new laundered merch and loving it. One of the things we did with staggering this launch was making sure that our warehouse shipping processes were updated. So we have updated those processes substantially, and we've heard all good things. We've heard all good things. So I'm glad you guys are appreciating it. And the hoodies are just, they're all so soft. Thank you, Casey Cat. It's good to see you in the chat. Nameless Musician said, I know I'm behind, but EDB is my emotional support streamer and get me through the workday. That's what I'm here for. The fact that I stream for the length of a lot of your workdays is not good for me. It's not good for me. Traders for lawyers. I'm ready for it. Sherry asked if I've seen the interview with the juror. No, I know it happened, but I have not seen it yet. Peggy Reardon asked, how could Jackson make such an error? I need more information, but I am wondering exactly what the language of the court's order was. And we heard Brennan read in court. Jackson said, I coordinated with them about their testimony and their qualifications. So is this still within this? The dash in between with Matt Bond said, hello, my spiffy legal mumbo jumbo talkie sister from another mister. Good to see you. Good to see everyone using my OnlyFan. Can't believe it spread that far. Matt Bond, it is good to see you in the chat. And yes, the OnlyFan was brought back in infamy today. So we are there for sure. So could the conversations be about testimony in the new trial? Elizabeth Ann, it seems that they were in between the two. Could it be? Anything is possible when we don't have all the dates. Ice Baby said, I feel like I'm waiting for my parents to pick me up at the principal's office. Yes. Nikki said most of that is for trial 2. The dates are going to matter. And if they are defense emails, the defense can clear that up. Cindy said, did Rebecca Yaros write this? I mean, the cliffhangers that we are left on. Phoenix Paw said, but isn't this a lot like what the Commonwealth has done? I need to know more. But if it is a discovery violation, we have discovery violations on both sides. We do. 100%. So, Angela Whitaker asked, if Karen Reed is convicted, but the federal case determines she's not responsible, do you think her conviction could be overturned? I said it before and I'm going to say it again, and I hate that this is the answer, and I'm sorry. It's going to really depend on what happens in the federal case and what happens in this case. So it just depends. Stina G asked if we could look at the sanction motions. All the motions I've seen for sanctions have been filed under seal. So no, we can't because they are impounded. So we will see. Lady FDD said those emails are after the last trial. The dated ones were in the middle of the last trial. If other ones are after the last trial, then we will see it. We will see it bear out for sure. I have not seen AJ's statement on video. If there is a statement on video, we'll cover it tomorrow because our mods and the producers have looked for it and we haven't seen it. Christina said, I just saw a 700-page motion from Jackson for a writ of habeas. That's not their motion to dismiss. A habeas motion is not a motion to dismiss. We're going to have to go over a lot tomorrow. Miranda said, I named my sourdough starter, Emily Doe Baker. That the D now stands for dough, chat. I'm here for it. EDB is ready. EDB is ready. And I hope your starter is fruitful for sure. So, Mo Sam said, my daughter and I love your perspective. You make law fun. The interview on Boston 25 with Ted Daniel, go watch. I will pull up interviews for tomorrow. We've got a lot to cover. There's a lot of information we just don't have. So I know that some want me to lose my mind. I am surprised that more is still coming out. I'm just surprised. I am surprised that more is still coming out. Am I surprised that Brennan has the same defense attorney style hyperbole and flair that we see from defense attorneys? No, he's a defense attorney. I'm not surprised, but he's acting as a prosecutor here. And the court is going to go through all the documents. We're going to see what happens next week. We're going to learn a lot more, I'm sure, between now and next week, because there's going to be filings. And we're going to go over all of them. And if there was a 700-page habeas filing, I guess we're looking at Karen Reed tomorrow too. I don't know why my lippy has traveled today. I'm deeply annoyed by it, but that's okay. We'll figure it out tomorrow. It is probably user error on my lippy, but we will take a look tomorrow and see if take a look at this. If there's a 700-page motion, we are not going to go through all the exhibits. We will see what motions are. We will see what the habeas motion is, and we will cover it tomorrow. I stream at 11 tomorrow. We are going to be in limbo for a few days, but it looks like we are going to be in a Karen Reed limbo. If I can find the video of Jackson's interview after court, we'll cover it tomorrow. Because again, Emily is still recovering. So 4 hours in, we will go through all of the habeas stuff. We will go through whatever is filed in court. We will go find it. I will see you tomorrow. There will be plenty. Whatever we were going to do tomorrow is going to get bumped. I'm going to get all Brennan and start banging the table. At some point this week, I very much want to do a court of public opinion, because the lore with regard to what's going on with Duo has gotten unhinged, and we need to talk about it. So we might have to duo. I don't know if we're going to get through everything, but we might have to duo. We're doing a court of public opinion at some point. If I am still feeling under the weather, we might bump our members only stream to next week, just so I survive the week and get into next week. So we will see. Don't worry. For all of you asking about the habeas motion, I want to see what their grounds are. We'll talk about it tomorrow. It's an appeal. We'll talk about it tomorrow. I guess we're covering Karen Reed tomorrow. So we're covering Karen Reed tomorrow. So download the Law Nerd app. I will see you tomorrow on stream. I will be here at 11-ish. We'll try to be closer to 11 because it seems like we've got a busy day tomorrow. Law Nerds, thank you for being here. Don't forget to get the Law Nerd app. It is free. It'll keep you in the loop. There's going to be a lot. Oh, today's going to be a lot. Tomorrow's going to be a lot. Today was a lot. You guys, today is still a lot. So I will probably have more thoughts about it tomorrow too, because today was much. Thank you for being here with me on the adventure of all the shit today, because wow, that was unexpected. Look, live court, can't make it up. Never know what's going to happen. It's why we ask for no spoilers in the chat. You never know what's going to happen in court. We might have to just be real time next week, so there can't be spoilers. We might just have to be within a few minutes of real time. We might just have to do it. Law Nerds, I appreciate you. You are the best. Remember, there are still items in the Law & Nerd shop. I'm going to share that with you now. There are still items in the Law & Nerd shop. Some of it has sold out. Some of it is still available for now, but we are running low on stock. So if you're like, this is the launch I want, now is the time. So we're going to show that, and then we're going to do the outro. So Law Nerds, thank you for being here, and I will see you tomorrow. Oh boy. Lots to come. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.